Hello, ladies and gentlemen. My name is Ben Gray. Welcome to my video documentary brought to you together with my website, bristolspotlight.tech, both of which are intended to set out to expose to the general public the venal, vile, and unbelievable criminality of such individuals as this man here, Mr. David Chidgey, who is a criminal barrister at Albion Chambers in central Bristol, just over the road from Bristol Crown Court. He has used his connections in 2 prosecutions against me to allow the police, in particular police officers, to get away with all manner of perjury and torture, perverting public justice, misconduct in public office, and so on and so forth. I won't bore you with any great details about the law before I crack on with the evidence that Mr. David Chidgey is beyond criminal. But I will just point out that some people might be concerned that a lot of these allegations are centered around criminal misconduct of 2, in this particular video, 2 Crown Court judges who work regularly or sit regularly in Bristol Crown Court. They are Judge Michael Longman and Judge Martin Picton. Both of these judges, as I say, were presided over the prosecution against me, 2 prosecutions against me that were conducted by Mr. Chidgey. And the allegations are centered as much, if not more, against these 2 judges than against Mr. Chidgey. You should take account of the fact, ladies and gentlemen, that there is a criminal offence specifically addressing criminal misconduct by judges. It comes up here on your screen now. It's called misconduct in judicial or public office. It's set out quite clearly at 25.381 of Archbold's. I won't read you a chapter and verse of it, but it says quite clearly that a judge, it's there in the title, a judge can be prosecuted successfully for any form of misconduct that would be such a willful, neglectful breach of their duty to act or not to act in a certain way that anybody properly informed about the case would have convicted the judges. So judges can be convicted for their misconduct in abuse of office, just as a drug dealer can be convicted for their abuse of the law. And 2 further points, come up on your screen now, are 2 offences that most of us are familiar with, but I'm just clarifying them: perverting public justice by making false allegations, and perverting public justice by concealing the commission of an offence, otherwise known as a cover-up. Both of those we'll hear about on the news all the time, but please bear them at the forefront of your mind as the case unfolds. The criminal elements to the complaints, the kidnappings and so forth, they pretty much speak for themselves, and people are basically familiar with the general principle of law that it is an offence to deliberately injure or hurt another individual.
Ladies and gentlemen, here we are in Bedminster Job Centre, 24th of July 2009, about just after 2 p.m. This is me here, Ben Gray, having been taken from reception over to the far left-hand corner off camera. There is another camera where I am now seated, but we shall go into what happened to that in due course. This is Mr. Philip Walters, who at the moment is seated passively, a man I've never met before, or he, me. And over here is Mr. Kevin Ryan, who's the security guard that in a moment will leave the reception desk and march over to where I'm seated, with Mr. Ryan complaining that I'm seated at the wrong type of desk. Within moments, you can see that Philip Walters rises from his seat and begins to come over towards me to involve himself in the argument over which seat I should be sitting on. Mr. Patch, it's worth noting, also comes to involve himself in the argument. At this point, Mr. Walters has bent me double over the seat, grabbed me round the throat, and is throttling me in no uncertain terms. I've smashed my arm against a wall in trying to keep myself balanced. I then march away from him, Mr. Walters, pointing out that he's a complete lunatic and probably dangerous. Mr. Walters then marches over to attack me again, and Mr. Ryan comes to attack me as well, and you can see just there where he's grabbed my tie in order to escort me away like a dog. And Mr. Patch has to, of course, get Mr. Walters to remove himself from my vicinity. Mr. Ryan then goes to grab my bag, and which is technically theft, and then goes to throw it out of the building in order to get me to leave. He then remonstrates with me for a considerable period of time, whilst I complained that I had been the victim of a savage attack, both from Mr. Walters and indeed from Mr. Ryan. Mr. Ryan continues to harass me, and a few minutes later the police arrive, and a few minutes after that I am arrested on breach of the peace.
So, ladies and gentlemen, that is the video of the incident on the 24th of July 2009 at Bedminster Job Centre. The video to some extent speaks for itself, but of course this video concerns the revelations about the corruption from the police, the collusion in all manner of perjury and perverting justice, and of course the violence itself that transpired after the police arrived to arrest me some few minutes after the incident that you've just witnessed on that video. Before I go into any of the details about this evidence that I have to support my criminal allegations against David Chidgey and Judge Michael Longman, let me just point out that you can download or look at all the files that I refer to in this incident, and indeed in the incident on the 3rd of August. If you go onto my website, bristolspotlight.tech, you can find the Chidgey File 1 by scrolling down the home page. Chidgey File 1 contains all the documents, some of which I'm going to show you on the screen here. So of course you can view them all for yourself at your leisure, should you be interested to do so. So let's deal with a few opening points about what happened after the police arrived. I was arrested, I was handcuffed in rear stack, and I'll come back to that in detail, taken to Broadbury Road Police Station, detained for several hours, tortured again by the police, and so on and so forth. But let's look at some of the evidence that was given after the incident, first of all from Elizabeth Evans. Now, as you can recall, I had gone off screen to the left, so the camera that should have been, the footage that should have been retained from the camera of that area was never seized. So I only had the testimony of Elizabeth Evans to support what I said had happened, which was that Mr. Walters had grabbed me around the throat here and pushed me backwards over the chairs, some of which you can see in the other video that you've seen earlier. And whilst he was pushing me back, I smashed my hand against, with my wrist against the edge of a wall in order to keep my balance, and I had a nasty scar there, or abrasion there. I had red marks and bruises from where Mr. Walters had grabbed me around the throat. And Elizabeth Evans, who was a witness, I'm not sure who she is or whether she's visible on the video that you can see, but she gave a statement to the police. She's an officer at the Bedminster Job Centre, and she said this: "I could see at the back of the centre in the seating area one male who I do not know," that's presumably Mr. Walters, "had hold of another male who I knew to be Ben Gray, which is of course myself, by his throat. He did this by holding him with his right arm." It's a bit confusing as to how he could be holding me with his right arm. I'm assuming that she means with the hand of his right arm, but that's not entirely clear. But largely, of course, her testimony agrees with what I complained Mr. Walters had done to me in full view of Kevin Ryan. But let's get on to Kevin Ryan. What does he say? Well, he tells me off about the seat. That wasn't in dispute. He was complaining that I was seated at a seat that I shouldn't be seated at, and for some reason this was a major security threat that he decided to harass me about. I tried to explain that I had a bad knee, and Mr. Ryan says this: "I turned my back to Gray and I went to put the seat back next to the desk, full stop. Within a few seconds I turned around and I could see the waiting area that Gray and another male I don't know, which is of course Walters, had hold of each other. They were holding each other by their clothing." So again, clear contradictions from Miss Evans and from myself. Mr. Ryan claiming that he did not see Mr. Walters grabbing around the throat at all, let's try and focus in on what Mr. Ryan would or would not have seen. The area that we can't see off screen is extremely small. It's no more than the corner of the office, because it tapers into a triangle shape. So he was right on. He was already involved in an argument with me when Mr. Walters appears, and you can see him get up from his seat and then suddenly becomes visible in the footage that we do see. So he's only out of our range of the video that we saw earlier for only a minute or so. In that space of time, in that small area, of course, Mr. Ryan would have been totally aware of everything that was going on, all the arguments. Both Mr. Walters and myself are large males. We were having an argument of some description that was just simply a follow-on from the argument about the chair, as you shall see from when I read Mr. Walters' statement. So this assertion that Mr. Ryan didn't see what caused the physical altercation between myself and Mr. Walters is utter concoction. He's simply lying in order to get round the fact that he claims not to have seen me be grabbed around the throat by Walters. So just going on to Mr. Walters' version of events, leading up to the altercation that we could see on screen, and then actually the altercation on the screen in Walters' case. He says, "I stood up near to him," that's myself, "and started to move up. I told him, 'You can't sit here,' and pointed where there was a space. He replied with a load of abuse, shouting at me I didn't want to fucking sit there. A few other people said there was plenty of room. He was really argumentative and kept saying, 'Why should I have to sit there? This is my country.' He then grabbed a chair next to him and picked it up. Several people moved as they were concerned he would throw it. I was already standing up, so put both my hands up to his chest and told him to calm down. There were a couple of other people asking him what the matter was. The security guards told him to leave, and he then started to run between the desks, shouting that the security guards were trying to strangle him. He then picked up another chair, and it came towards me and brushed my leg. I thought it was going to hit me, but it did not cause any injury to me, so I wasn't worried about it. When he did this, he was approximately 6 feet away from me." Well, we can see from the video here that you've seen already, but here's just another replay, a photograph of him and the distance I was from him when I pick up the chair. He's right on top of me, as you can see. As soon as this happened, my name was called, so I went to my appointment. So those are the three versions of events, all of which contradict each other absolutely. I mean, Mr. Walters doesn't even claim that I had my hands on him, so the only person to claim that I'd actually made physical contact with Walters, apart from when he's attacking me with the chair later on, but in terms of when we're off screen, is Mr. Ryan. Of course, almost every word of Mr. Walters' evidence is false, because we can see from the footage that he has come after me, that I don't go running away from the security guards. Initially, I simply move away from Walters. I point at my head that he's clearly deranged and absolutely dangerous. In response to this, Walters then pursues me. I then run away from him and pick up a chair when he's right on top of me, in order to create a buffer between myself and him, and put the chair back down immediately. And of course, Ryan then pursues me and grabs my tie, as you can see here, quite clearly grabbing my tie, attacking me when I have not attacked Walters at any stage in the proceedings. And indeed, I've been a victim of 2 attacks from Walters, and yet Ryan not only attacks me, but he then grabs me by the tie, pulls me out of that area by the desks, and then goes to grab my bag and throw it out of the building, which is theft, technically, because he's taking my property, which doesn't belong to him, without my permission, and moving it to somewhere else. And if you look at the Theft Act, I won't bother to bring it up on the screen, it's all fairly common knowledge, then it clearly says that removal without the person's permission of property is theft. So he's stolen my bag, he's physically attacked me himself. And so those are the 3 versions of events. The statements from Evans and Ryan were given on the day, on the 24th of June. The statement of Walters was given later in September. Walters formed no part of any investigation on the day itself. There is clear evidence that the police looked at the CCTV evidence, and we'll come to that in due course. And of course, we'll come to why the CCTV of the corner, which would have clarified exactly who was the victim of what instantly, was never taken or never seized, and was disappeared in due course. So let's move on to the reasons for my arrest on the day. Well, what I have in terms of the information around that incident is a report that was made by an Inspector Alan Chambers, collar number 3274, and he composed a report that he, excuse me, he concluded, I think it's November 2010. But in any event, his report here is the information that was gathered by him from the various parties as to what had actually happened. When as a part of my complaint, Mr. Chambers works for Professional Standards Department. I use the word professional standards in the loosest possible way. And he investigated my complaint that I had been the victim of a savage assault from Walters and Ryan, and then false arrest, which is in fact kidnapped, technically. Obviously, I'll show you the authority on kidnap, although we all know it. It's removal without lawful authority of a person from one place to another without justified excuse, which clearly applies to my case. So I was kidnapped by the police on the day, and complaints about perjured and false statements about what had happened leading up to my arrest and then afterwards. The first person that is addressed by Mr. Chambers' report is a woman called Ruth Leesey. Ruth Leesey is a manager. We shall see her physically in the video of the 3rd of August, because she instigates literally a physical fight between myself and Mr. Ryan, who we've also seen, and another man called Mr. Povey, and a third man called Mr. Dick. There's no point in dealing with that now, because that's dealt with in my next video. But Miss Ruth Leesey, as I say, is the manager of the court. She was there on the day, but she gives this information to Inspector Chambers' report. Mrs. Leesey is the manager of Bedminster Job Centre. She did not witness the initial incident on 24th of July, but when alerted by other staff, she went to the public area where she sat with Mr. Gray, who she describes as being very irate, shouting and screaming. She recalls that he was waiting for the police and appeared to consider that he was the aggrieved party. Several officers arrived. Some spoke with the other person, who presumably was Mr. Walters, who had been involved in the incident, and some with Mr. Gray. She thinks that the officers may also have viewed the CCTV footage. The officers then asked Mr. Gray to leave several times. They were patient and calm and gave him every chance to leave. Mrs. Leesey was happy with this, as all she wanted was Mr. Gray off the premises. So that's her version of events. No information that I had shown her an injury or several injuries received from Walters. No information about that I'd given her any complaint about being attacked by either Walters or Ryan. No concern or interest as to what the incident actually was that had happened while she was the manager, or why I was the scapegoat and that she wanted me to leave. Even if I was irate and shouting, which is an absolute lie, then surely that would have been potentially the natural response to being attacked several times by, including the security staff, for absolutely doing nothing except sitting in the wrong chair, allegedly. And of course, when we go back to Walter's statement, we can see that he's got up from the chair to deal with me about the chair as though he is part and parcel of the security team, and as though the chair and which chair I was sitting on was any of his business. Of course it wasn't, because he is a client of the job centre the same as me, so it was none of his business. He was literally harassing me, even if Mr. Ryan wasn't. And of course all of this led to the violence that I had, when I had not raised a hand to anybody except when I lifted the chair as a last resort, because this huge male was clearly coming to bash me and attack me a second time. So that's Mrs. Leesey's point of view. She just wants me off the premises, whoever's within the wrong, whoever was the victim in the case, and that apparently is that. And then we come to Mr. Patch. Now, Mr. Patch we've seen already in the video, and he, excuse me while I just get my paperwork in order. He is the security guard colleague of Mr. Ryan, and he says this, apparently according to Mr. Inspector Chambers. Mr. Patch is a security guard and was on duty at the job centre 24 July. He did not see how Mr. Gray initially came to be in dispute with another customer. He and his colleague, Mr. Ryan, separated the two parties and waited for the police. Well, let's just deal with that in short order. Well, we can see here is a still from the CCTV footage where you can see that Mr. Patch has become aware that Mr. Walters has risen from the chair to deal with me from his chair to deal with me about the chair that I'm sitting on. And you can see that Mr. Patch's attention is immediately drawn to Mr. Walters getting up and the inflaming of the situation that is about to occur. This statement, and presumably there was a witness statement from Mr. Patch, is basically a complete and utter concoction. He saw the moment that Mr. Walters got up, so long before there had been any altercation between myself and Mr. Walters, to the moment that he then has to intervene with Mr. Walters to get him away from me from attacking me a second time. So pure and simple, utter concoction from Mr. Patch. And of course he's perverting public justice because he's concealing the commission of an offence in terms of the attack from Walters by lying, stating that he didn't see the initial incident. He and his colleague Mr. Ryan separated the two parties and waited for the police. Whilst waiting, Mr. Gray was abusive to everyone present and was told to sit down and be quiet. So that's Mr. Patch's apparent testimony. He's just lied about not seeing exactly who was at fault, when obviously the footage proves that he's concocted that from start to finish, and then he just blithely says that he admits that he's told me to shut up and be quiet, like a dog, regardless of the justifiable distress I'm in about being attacked a second time. And of course, as we can see, here's for instance, the lady who was near or standing near to where me and Walters initially where Walters attacked me, and there was a confrontation due to the attack. She is obviously frightened. She's moved away from where we were to sit down again. She's a key witness to the events, clearly a victim of Mr. Walters' violence. She's of no consequence to the police or, in due course, Mr. David Chidgey or Judge Longman. And indeed, there were children at the further end of the job centre. They were, of course, going to be involved in the altercation once Mr. Walters pursued me to attack me again. It's obviously fortunate that I didn't retreat further into where other people were. And, of course, none of this is of consequence to the police and David Chidgey, etc. She's not questioned. There's no mention of her existing in the police report. She was easily identifiable. She was there for an appointment, so they would have known who she was, even if she had left once the police arrived or shortly thereafter. And as I say, she is another victim of this diabolical violence on the day. Mr. Ryan has given evidence also to this inquiry, or either that or his statement is relied on. Mr. Ryan was also on duty on at the job centre 24th of July. He recalls that Mr. Gray first came in. When Mr. Gray first came in, he was being a nuisance. He sat in the wrong chair. Well, am I being a nuisance by sitting in the wrong chair? This is an empty desk. Nobody's being bothered by me sitting in a chair until Mr. Ryan has to come over from the other side of the job centre to interfere, to make a complaint about it. That's not being a nuisance by any chalk. It's sitting in the wrong chair. And of course, I complained that I had a bad knee and I needed to sit in that type of chair because it was more comfortable than the other chairs I was sitting on. It may have been that I made a mistake, but it was not deliberately intending to be a nuisance to anybody. Indeed, I was completely quietly sitting, minding my own business, waiting for my interview. Mr. Ryan goes on to say he then got into a dispute with another customer. He and his colleague split the two men up, and the other man was then calmed down. So that is Mr. Ryan's version of events according to the police. Of course, Inspector Chambers has seen the video of the violence that occurred from Mr. Walters, and we'll come to that in a moment. But of course, he knows, therefore, that Mr. Ryan is simply whitewashing all the violence that was meted out against me. There's no mention that Mr. Ryan himself has grabbed my tie or thrown my bag out of the building, etc. So again, a complete whitewash, meaningless in terms of any sort of investigation. So, ladies and gentlemen, that's some of the testimony from the civilians, or the what purports to be testimony. God knows what it should be amounted to, but lies and whitewash is primarily the order of the day. Then there's the issue of the CCTV. There's two issues surrounding the CCTV. First of all, there's Inspector Chambers' own view about the footage that was taken by the police and that we have seen. But before we get to that, there's the CCTV of the area that involved all these witness statements and my complaint and Miss Evans's testimony that I had been strangled by Mr. Walters because over some dispute over a chair within seconds of him getting up from his seat. Alan Chambers says this: the CCTV from the job centre relating to the incident 24th July, which has been available for the purposes of this investigation, is from a single camera. An inquiry was made at the job centre shortly after the investigation commenced, which revealed that any other CCTV recording made in July had by that time been overwritten. No witness makes reference to having viewed any other CCTV in connection with the incident 24th of July. So, of no interest to Inspector Chambers is what has happened to the key evidence that proved that I was the victim of a savage attack from Walters. Walters is being permitted, with clear express permission of the police officers, of the security staff, as we've already seen, and Inspector Chambers, and then all the way up through to Judge Longman, to simply savagely attack somebody that's caused no harm to anybody over a dispute over my sitting in the wrong chair that clearly wasn't any of Walters's business to begin with. And no explanation is provided as to why the footage was overwritten. It needs to be overwritten. The general process in job centres and most establishments of that kind is that the CCTV is generally overwritten after a few days or a few weeks, usually. But of course, the only reason it was overwritten at all was because PC Marr, who was the investigating officer into the alleged affray, which I was later accused of committing, was never taken by PC Marr and was never pursued. And indeed, when I turned up on the 3rd of August, it was primarily to record evidence of a camera in the corner of that building to ensure that there was no that I could at least prove that there was a cover-up and an attempt to pervert justice. Again, the allegation of perverting justice is when somebody deliberately conceals the commission of an offence. One of the key ways of doing that is destroying evidence that an offence has occurred. There was no dispute from. We have a witness statement from Miss Evans that I had been the victim of a violent attack. So there was my complaint and Mrs. Evans' backup testimony that needed only to be confirmed with the footage itself. Without the footage, of course, Ryan and Walters could then simply invent their own versions of what had happened, both of which happened in and of themselves to contradict each other. So, again, a threat to everybody, ladies and gentlemen, if the police, together in cahoots with people like David Chidgey of Albion Chambers and Judge Longman, are simply like in some Orwellian nightmare, destroying evidence as it goes along in order to cover up, violence and obviously cover up the fact that Ryan and Walters had lied as well, which is an offence in and of itself, to say nothing of the missing CCTV. So we move on again to the CCTV that was viewed by Inspector Chambers that we have seen ourselves on this video. Inspector Chambers says this: the CCTV available from the 24th of July is inconclusive. It shows that Mr. Gray was involved in a dispute with another customer. The available footage in isolation would suggest that the other customer was acting aggressively towards Mr. Gray as he moves towards him. Mr. Gray's action in picking up a chair could well be interpreted as defensive. Well, look at the wording that Mr. Chambers is using. He's deliberately using words that shy away from simply describing what has occurred. Walters is not acting aggressively. He's carrying out a criminal assault. Unless I'm standing there with a knife or even accused of verbal threats towards him, perhaps, may justify Mr. Walters coming over to attack me for a second time. But of course, he's the one who's attacked me to begin with. We have Evans's version of that. Even Walters himself doesn't claim that He says that I picked up a chair, but I've moved away from him. You can see me standing there, not being a threat to anyone. His coming over to me is an assault, and of course, any further evidence surrounding those circumstances wasn't investigated anyway, including the key CCTV footage. So he's using the words very ambiguously, but he's at least he's taking my side, and he's explaining that when looked at in isolation, I appear to be the victim, and yet for some reason he just then ignores this fact in terms of all the testimony, in terms of the fact that Mr. Ryan doesn't even bother to explain why he's not even questioned about why he's attacked me if I appear to be the victim according to Chambers, and so on and so forth. I mean, hopefully by now I don't need to be saying much of this, because it's all self-explanatory in terms of the heinous and vile criminality that is surrounding this whole investigation. And I can't help but keep trying to stress the threat to the general public. If nobody cares about me, that's their entitlement. Why should they? I'm sure there are people that are far worse off than Benjamin Gray, but the threat generally to the rule of law and to other members of the public who are just being treated as inconsequential peasants, mere collateral damage in the cover-up of the police in order to justify the violence and kidnap of myself. Then we have the reasons for my being arrested given by the officers. Now, there was on the scene when the police turned up a few minutes after the video, an Inspector Crockford. He is of quite senior rank. He's senior to the sergeants and the police constables, and he's supposed to have a little bit more training and obviously experience in crime scene investigations and gathering evidence and so forth. And you can see that he simply puppeteered the whole arrest of myself in order to scapegoat me and cover up the offence. Inspector Crockford says in relation to why I was arrested, Inspector Crockford reports that he attended the job centre. An officer was speaking with Mr. Gray and trying to establish what had happened. Mr. Gray was being obstructive and refusing to explain what had happened or give personal details. Staff told Inspector Crockford that all they wanted was for Mr. Gray to leave and that they would be taking action to ban him from the premises. It was clear that Mr. Gray was interrupting the business of the job centre, and in the opinion of Inspector Crockford, his behaviour was such that he was committing a breach of the peace, and members of the public would have been in fear of being harmed. Well, this is utter gibberish. I mean, whether or not there's been a breach of the peace is obviously, he's talking about the earlier incident. There's nothing in my behaviour. I mean, it's not clear. In fact, let me just reread that. His behaviour, whether the behaviour that he's talking about is my behaviour at the scene at the time that Inspector Crockford is present, well, being obstructive, which I was accused of being, and refusing to explain, which is the two aspects of my behaviour that I'm accused of doing. Utter lies, of course. I would hardly have been keeping silent about this attack from Walters. Why on earth would I take that approach? I would have had to be completely mad, and I hope you can see I'm not completely mad. In any event, being obstructive or not cooperating with questions is not a breach of the peace. A breach of the peace, ladies and gentlemen, is clearly set out in common law authority. It is when there is actual violence or threatened violence by an individual that can justify an arrest from either a civilian or a police officer, and none of that is alleged in terms of Crockford's own description of me. Here's the authority of breach of the peace, and mere agitated behaviour, even waving bags around, which is a authority in a test case, does not constitute a breach of the peace. There has to be actual violence. Insofar as the earlier incidences occur, well, Crockford has no idea what's happened. He doesn't refer to looking at CCTV, and if he had, he would have seen what Inspector Chambers had seen, which was Walters appears to be the aggressor. So in terms of why I would be a threat to other people, when I was the victim certainly of the attack that's shown on the footage, and indeed even Miss Elizabeth Evans has verified that I was the victim of violence from Walters. Walters was permitted to stay. There's no mention that Walters is questioned or in any way party to the police concerns about violence. Walters, who was the actual violent individual, was allowed to remain with all the other innocent parties who are far more likely to be terrorised by Walters, given that he was the aggressor, even according to Inspector Chambers, than myself. But that is simply ignored in the report in terms of any finding or basis to arrest me. It is not a lawful ground to arrest somebody. I should just to clarify, I'm sure most of you who are watching this video know this, but the police cannot simply say, we're going to arrest you for being violent or doing some act either now or in the past if you don't leave the premises, or if you don't do a certain act, or if you don't go and wash your hands, or whatever. The police powers are there to prevent to investigate crimes in the interest of justice. They're not there as henchmen, puppets of the job centre staff, because they want some individual removed, regardless of whether that individual is the victim or perpetrator of crime. That is not police powers to arrest for a breach of the peace or any other authority, is clearly not legal, and is an abuse of the power to arrest. And obviously we could go into great detail about what powers they have under the PACE Act, Section 24 and so forth, but you will clearly see that their powers do not include threatening to do something, to arrest somebody if they don't carry out a certain act. I mean, obviously they can if they are carrying on with a particular criminal offence, but that wasn't alleged by Officer Crockford. He simply says I was being obstructive, and that was about the end of it. Then there's PC Hawkins, who was the arresting officer. He says that he recalls that when they were dispatched to the job centre, the incident was described as a fight between two customers. He spoke with Mr. Gray, who told him that he had been in a bad mood when he had first arrived at the job centre. Well, here am I, even if I did say that, I don't think that's particularly accurate, and even if it is, it's taken out of any context of anything else I said. But here are me not being obstructive. According to Crockford, I was being obstructive. According to Hawkins, I was giving some account of what had happened. He then began to shout about the service and the war, and of course the terrible English used by Chambers doesn't make it clear whether I'd begun to shout at Hawkins about the war or the service, or that this was the complaint, because this was complained about by Walters and Ryan earlier in the day. So that's not at all clear. It's complete fabrication if it's being accused of at either occasion in terms of that accusation. He refused to give his personal details, absolute nonsense, or it was probably the circumstances in which I was being questioned about the personal details, as though I was the suspect at this stage, without the police having made any inquiries as to who had done what to who. A female member of staff told him that Mr. Gray was well known to them and had been banned from other job centres. She gave us details. A member of staff also said they wanted Mr. Gray to leave as he was stopping other job seekers from carrying out their business. Well, how I was stopping other job seekers from carrying out their business is not explained or indicated. I simply wanted to report the attack from Walters in the interests of public safety generally, and because I was the victim of a serious crime in full view of 2 CCTV cameras. And PC Gaunt, who's another arresting officer, says identical stuff to Hawkins. So, ladies and gentlemen, that is the account of what happened leading up to my arrest. Ladies and gentlemen, the footage from my arrest was again not taken, but I was handcuffed rear stack. The handcuffs were placed on the very injury that I had received from Walters to my wrist when I had smashed my hand against the edge of the wall. This dug into my wound that was already received, creating more wounds on top of my wounds with the handcuffs, rear stack, causing unbelievable agony. I was then pushed into a police car so that my back was pushed against the handcuffs that were placed rear stack, and of course police handcuffs are rigid plastic, so that they create incredible pain if there's any stress put on them. The handcuffs were put on too tight, so they were cutting off circulation to my fingers, which is use of the handcuffs as weapons, especially when the police are making an unlawful arrest, because you're being stubborn, you're not you created a situation that they are annoyed about, which means paperwork for them and no conviction for them. They simply get their punishment in before anybody's actually been investigated by illegal use of the handcuffs as torture instruments, all of which people like Judge Longman and Judge Picton and other judges at Bristol Crown Court, etc., are well aware of the injuries that are often received by suspect. Sometimes they are, of course, deserved when people kick off and resist their arrest. There was even if you look at the documents supplied, there was no suggestion that I was resisting arrest. Indeed, it was even affirmatively stated that I wasn't resisting arrest, and yet I was inflicted with this incredible pain. And they say that reasonable force was used to arrest me. Well, reasonable force is obviously determinative of what is the basis for your being arrested. And my being arrested for not leaving a job centre shouldn't really require use of handcuffs to carry out that arrest. And even if handcuffs need to be used, then of course front stack is more comfortable than rear stack and less humiliating and degrading and painful. So anyway, I eventually arrived at Broadbury Road Police Station and confronted by Police Sergeant Booker, who is the officer that then has a duty to decide whether or not there is a lawful basis to detain you. And you can see on the custody report here, I was told, it was information there that I was, the circumstances of my arrest are given as throwing chairs about. Well, of course, we can see from the video I wasn't throwing chairs about. Nobody would argue that I had thrown the chair at Walters, and Walters' nonsense about me having a chair or threatening him with a chair when we were off at the scene, which wasn't seen by either Miss Evans or Mr. Ryan. Obviously that was concoction, but he doesn't suggest that I tried to throw it on that occasion, even if we believe for a second anything Walters has to say. So I've now been detained effectively for a breach of the peace, even though I wasn't committing a breach of the peace. I've now been accused of throwing chairs about, which is going to lead to my eventually being bailed on suspicion of a fray. And then I'm led off to a police. Handcuffs are eventually removed, and I'm taken to a police cell. The police station cell stinks of urine. So I complain and ask for a transfer, at least to a more hygienic cell. That is refused by Booker. I cover up some of the camera because the camera is pointing at the toilet, so I'm unable to use the facilities without being filmed, which is deeply perverted and a strange approach for the police to take, because I know that they have to keep observation of a detainee, but of course I haven't been lawfully detained. I've been kidnapped as the victim of 2 violent offences, so by now I'm obviously deeply upset, and Police Sergeant Booker is refusing to engage on the reasons for my arrest and the fact that I'm now being detained in a stinking cell. And in a moment of fury, after Booker insisted I had to stay in the stinking cell, I throw a bit of water at him in a cup that I had in my hand as he's closing the door, and a little bit of water splashed on his face, drinking water that had been given to me by a custody officer slightly earlier. He then goes away, orders for 2 officers to come back to the cell, burst into the cell, throw me to the floor, handcuff me, rear stack again. So I've now got injuries on my injuries on my injuries from the handcuffs being applied too tightly. I'm put face down on the floor. My legs are bound in belts so that I'm now basically a maggot on the floor, which is obviously the point of degrading me to prove that I am absolutely the lowest form of species on the planet. And I'm left there being monitored by PC Mar, who was to become the investigating officer into both an alleged assault against PS Booker with the water, and then and of course with the incident involving Ryan and Walters earlier in the day. I'm left there for about half an hour. PC Mar is monitoring me with a little notebook, taking notes about things I'm saying. I eventually asked to go to the toilet. That is refused, so I have to urinate in front of this female police officer, and then I'm eventually released from their handcuffs, and I'm put into clean sort of paper trousers that the police have for murder suspects when they have to take their DNA and stuff like that. A scab has come off my knee when I was being thrown to the floor by the officers, so this is now covered in blood. I now have a dripping open wound from my knee. And eventually I'm interviewed by PC Mar some hours later, and then released. PC Mar gives her statement. She gives no information in her statement about the information that I've given her about the assault from Walters. That's completely covered up in her report about the interview. Her only mention in the police statement that she's given is concerning the altercation with Booker, and Eventually, I'm released and charged with assaulting Police Sergeant Booker and another officer, I believe, claimed to have been a victim of the water droplets. That was obviously eventually discontinued, and one of the reasons for the discontinuation was because the video from the CCTV camera from the cell had disappeared again. So, ladies and gentlemen, that's we just dealt with the incident on the 24th of July 09 at Bedminster Job Centre between myself, the job centre staff, and then the police. That's been canvassed, and of course we'll come back to that when we come to the trial against me for common assault against two of the security guards, Paul Povey and Kevin Ryan, in due course. But before we go on to canvass the incident of the 3rd of August and the evidence surrounding that, before we go on finally to the trial itself before Judge Longman, let's look at the footage of the incident that was recorded of the incident on the 3rd of August. Please bear in mind, ladies and gentlemen, that this is a second-hand recording, in that I had to, because I wasn't able at the time, I knew much less about computers than I do now. The footage is recorded in sections onto my own handheld camera from the DVD, because I didn't know how to download the DVD footage onto my video for posterity, and the DVD itself subsequently got damaged whilst I was in custody in relation to the trial. I no longer have the original footage, and the CPS and police are both claiming they no longer have the footage in question. So it's a little bit out of sequence. So the first bit of footage you see is actually, I think, occurs somewhere earlier on in proceedings, and the reason why it's all a bit rough and ready is because it's not actually a first-hand recording of the evidence of the incident. It is, however, I think contains almost all of the incident itself. It's just a little bit out of sequence and a little bit and rough and the low definition. But otherwise, you can have a good idea of what's going on. Just before we come onto the footage, here is a quick snapshot from the footage that just individualizes who is who in the footage you're watching. Miss Lisi at the back, then Mr. Birchill, and then I think it's that's Kevin Ryan you can see there, and Paul Povey, and the lady that you can then see, or the woman you can then see Miss Lisi talking to, is, I think, Karen Rockatch, but I may be wrong. But you can see that the main players in the matter. Of course, the most important individual I would suggest is Ruth Lisi, because she was the manager who orchestrated what I claim, and what I hope you can see is clearly criminal violence of quite a serious order, not least as it involves other civilians as well as myself in the altercation, as you can then see. But without me waffling on, let's have a look at the footage itself.
So, ladies and gentlemen, here we are at Bedminster Job Centre, the front doors, where Povey there is touching his face as if to imply that he's been punched, which of course is a complete concoction. Ryan has stood next to him, and then here they both are using violence to keep me from coming up the ramp. So it's not just the doorway they're now objecting to. And here we've jumped back a bit to where I've come up the ramp with my camera, and Povey and Ryan are sort of putting their arms across me to try and keep me coming in. Ryan's face there to the left, you can see his hand is right in my face there, and Birchall Dick is just behind Povey, who is just behind Ryan, who's at the front of those three. At this point, I'm remonstrating and demanding my rights under the Human Rights Act, Article 5, liberty and security. Here I'm being denied both security and liberty with the violence. That's Miss Ruth Lucy there turning to her colleague. And you can see here a gentleman is trying to get through, and he's caught in the melee as well, so he's at risk. And then I try and move in, and Ryan and Povey go ballistic to try and keep me from entering, throwing me against metal railings Ryan's arms right in my face. He's having to force that other gentleman to squeeze past Ryan's rear end in order to get through into the building. And again, they attack me as I try and make manoeuvres into the job centre. At no stage can I be seen lashing out. My hand is down by my side, the one that isn't holding the camera there. Ruth Lucy passes me a letter that purports to ban me from Field Waterhouse Fisher, which of course can't ban me because there's no order or injunction. And here I would knock away Povey's hand, which is the only time I lash out because his hand is right in my face, going near my eyes. And another pause as I'm about to re-enter again. I'm remonstrating again about my rights, and again Ruth Lucy tries to pass me the letter, which I ignore. And then there's another pause as I remonstrate, and in a moment there's going to be further attacks from Ryan and Povey. And so here I try to get through, and you can see the way Povey in particular gets underneath my arm, pushes me against railings. All three of them bundle in, shoving me against the railings. Could have easily caused major damage, injury to myself. I could have gone over the railings even. I could have grabbed hold of one of them, pulled them over. Again, here they go, throwing me against railings, smashing me as though I'm just an inanimate object against railings, pushing me down the ramp, kicking after me. You can see Povey to the right. He's shouting "fuck off" at the top of his voice. You can see his lips moving there, shouting "fuck off." And there you go, "fuck off," he's shouting, lashing out at me. There's women around, children. Povey is standing there, bellowing his head off that I should leave. Other people are being distressed by they want to come into the job centre. They can't because of the violence, being meted out from the security guards. And this is all to keep me from entering the job centre, committing no offence, no order against me not to enter, and certainly no legitimate use of violence for the mere act of trying to enter the job centre. And there's Karen Rockash, I think, is to the right, who's the colleague of Miss Ruth Lucy, and then they slide the doors to, potentially trapping fingers in there, no concern to anybody, no warning that they're going to do that. And you can see the lady there is on the other side of the building observing matters. And she was later to say that she was extremely distressed by the incident as well.
So, ladies and gentlemen, that is the footage of the second incident on the 3rd of August. We've already canvassed everything that happened on the 24th of July, a couple of weeks before, and this is my attempt to get back into the job centre, apparently in the face of some ostensible ban, mainly because I want to record the area of that's off screen in the 24th of July incident, where the altercation between myself and Walters occurred, because I want to ensure that the police then pursue the footage from the camera where that area is. But the guards are going to make it clear that they're not going to let me come into the job centre, referring to some ban. Statements from Mr. Povey and Mr. Ryan both make it clear that I have called the police before I'm about to enter the job centre, asking them to be present so that there's no public order incident and that other members of the public are secure, as well as myself, and of course the job centre staff themselves, because they are complaining that I'm to some extent violent, and of course these complaints led to my false arrest, false imprisonment on a couple of weeks before. So there's no dispute that the police were called, apparently by both parties, me and the job centre staff, but the police of course washed their hands of it. And of course we can see from the footage that innocent members of the public, if that doesn't include me, it certainly includes the other people that want to use the job centre. They're caught in the crush between myself and the altercation between myself and the job centre staff. Their security should be paramount. The irony that the security staff are putting in danger through their violence towards me, and assuming their violence towards me is in any sense legal, of course it isn't, but even assuming that it was, they're also using violence effectively to the other members of the public, and heaven forfend that some child had tried to come in between that altercation, all of which is quite obvious. So again, we look at Ruth Lacey's statement. Ruth Lacey is the manager. She has overall responsibility to whether force can be used and what force can be used and so forth. And she has orchestrated this confrontation between myself, Povey, Ryan and Birchill. She knows that I'm present and that I'm probably going to be coming into the job centre quite soon, and that I've called the police, and she can take steps, of course, to ensure the police are there when and if I try to get into the job centre, but she doesn't do so. She gives a statement that's dated the 11th of August 09, in which she says, on Friday, 24th of July 09, I became aware of an abusive member of the public in the office downstairs. When I went downstairs, I saw security talking to a very irate member of the public. I saw the male member of the public to be Benjamin Gray, aged 43. I've met Benjamin before earlier in July because he made a complaint. Benjamin was quite irate, shouting, screaming, and he was very agitated. I do not recall what he said, but I sat with him and calmed him down until the police arrived and arrested Benjamin. Why I've been arrested is not made clear. She's already given a statement that we referred to over the 24th of July incident, in which again she's completely unconcerned about who has actually been the victim of violence under her watch, or why, if I was in any sense irate, I deny being irate, but even if I was, why that might have been the case, considering that I've been the complainant of a serious violent criminal offence. She then goes on to deal with she mentions 27th of July, where she'd seen me hovering around the job centre but not tried to come in, so we'll move on to that. She then goes on to deal with the matter of the 3rd of August, the incident that we've just seen, and she says in relation to that, on Monday, 3rd of August 2009, I came into work, and upon reading my emails, I found that the department solicitors, Field Fisher Waterhouse, had sent me an email stating that a letter and banning order had been sent by them to Benjamin Gray's home address on 31st 0709. Well, what she says is a banning order is not a banning order. A letter saying that I was banned from the job centre by courtesy of Fisher, Field Fisher Waterhouse is not a banning order. An order, in any sense of the word, needs to be a formal injunction from the court after hearing the case, and the court then decides whether or not somebody can be banned from a particular area of the UK, and therefore their basic rights to liberty and security are contravened by virtue of the order that's supposed to be in the interest of justice. But no such order has been made. It's a complete concoction to refer to it as an order. It's simply a letter that has been paid for out of the taxpayer's purse to try and dissuade me from coming back to the job centre. She then says that she's produced this letter to the PC Botley, and this is in relation to the prosecution against me, the investigation and prosecution that occurred after the incident that we've just witnessed. Well, we don't need to go into details about her evidence at the moment. We'll come back to the final part of this. The documentary will be on the trial and judgment itself, and the egregious and vile way in which Judge Longman covers up and colludes in the most horrendous perjury and violence from the job centre staff and Mr. Walters. So we'll come back to that in due course. But just dealing with the fact that she believes that an order's been made, or she claims to believe that an order's been made when it hasn't. There's no order being made. And of course, if there was an order, it would simply allow the police powers of arrest and potential criminal proceedings or civil court proceedings if I breach the order by way of an injunction. Ryan, meanwhile, has made a further statement in relation to his evidence in the matter. And Ryan says that I've been banned. She said he repeats the fact that I've been banned courtesy of this letter from Field Waterhouse, And he says that the ban is this is because Gray is banned from the site due to past incidents where he's been fighting with other customers, running around the office, throwing chairs, and causing a disturbance. Well, of course, we've seen the footage. We don't need to repeat that. But the I've been fighting is absolute outrageous perjury. He knows full well that I was attacked by Walters unjustifiably whilst off camera, and then I'm attacked again by Walters in front of the camera, and then attacked by Ryan himself. And in terms of throwing chairs, there's no dispute that I wasn't throwing a chair. I picked it up momentarily. So we don't need to revisit that. He's just repeating in his further statement made on the 3rd of August the concoctions that have led to my being banned from the job centre. So he says also that he refers to the phone call with the police. He says that I heard Gray, this is whilst I'm outside the job centre, before I've tried to come in, some 20 minutes, half an hour before I have tried to come in, I heard Gray say, I received a letter telling me that I'm banned and I'm not allowed inside, but they can't do that, end quotations. He then says, I couldn't hear all of the conversation due to the noise of people coming and going, but I did also hear him say, I'll meet you round the corner. I think he was on the phone to the police as he called them before in the past. So the police could have avoided any violence of any description because they are contacted by me, and I believe Miss Lisi or somebody also called them, and clearly should have done even if they didn't. So I've tried to avoid any kind of violence towards me or having to act in self-defence from violence by calling the police long before the public order incident occurred. Of course, the police are there to preserve the order, the public order, not simply react to an offence or potential offence once it's potentially occurred. He then goes into the violence itself, and of course we've seen the footage, and he's complaining that I'm coming right into his face. He says I was shouting aggressively, so he was referring to me, so he, Benjamin Gray, was shouting aggressively and was coming right into my face and Paul's face, this is Paul Povey, who we'll meet in a moment, and thrusting the camera right up in our faces. He then lunged forward and took 2 swipes at Paul. He used his left hand that was clenched into a fist. The first strike missed, but the second one hit Paul in the face. Well, we can see from the footage, at no stage in the footage can we see me strike Paul Povey. This is later justified by having apparently occurred off screen, where you can see me going down the ramp and off camera, and this was later in court to the extent of the time when the strike occurred, and which was why it couldn't be seen on the camera. But of course, it's preposterous to say that I'm coming into his face when he's standing by the doorway blocking my entrance into the job centre. The job centre staff have no powers to use violence against members of the public who are trying to get into the job centre just because a letter has been sent by a solicitor saying that person cannot enter the job centre. Article 5 of the Human Rights Act says clearly that every member of the British public has a right to liberty and security. And of course, unless I'm actually committing an offence or about to commit an offence, those are the only legal basis upon which somebody can use force. A civilian or a police officer, but particularly civilians, can use violence against members of the past, put their hands on members of the public to stop them doing something or to prevent them going somewhere, only on the basis that it's to prevent crime. And I'm not committing a crime by entering the job centre. It's a public job centre. It's my job centre in terms of the needs to sign on at that job centre. And the job centres, of course, are built and designed for those who are unemployed and need to find work. They're not owned by members of the security staff or Ruth Lisi or Field Waterhouse solicitors. It's a public forum, public building for members of the public to enter. But all this is self-explanatory. And of course, everybody knows generally that you can't go around attacking people unless you're actually acting in self-defence or preventing them committing a crime that can only be dealt with by way of force at that particular stage. He then claims that I also hit. So he goes on to say. In a further part of his statement, that I've also hit him. Once again, he tried to barge in, but we managed to keep him out. He then hit me in the face. I think it was with his left hand, but I do not know if he hit me with his fist or his open hand. So they're both now claiming that I've hit them. And of course, they're both going to be claiming later that the reason why it's not shown on the footage is because it's off camera. But you can see all the footage. It's a bit broken up, but I think that's all the footage. I was recording it. I no longer have the original footage, and I was recording it piecemeal because I didn't then know the technology to have the footage transferred onto from the DVD that I was given in evidence onto the computer. But in any event, you can see there that there's no suggestion that I've hit anybody. I'm simply trying to come in, and that I'm the one who's being attacked violently. And of course, even if I did hit them, I would be justified under the law of self-defense because they're carrying out a criminal assault against me, which is pretty clearly putting my life in danger, and of course putting others at risk who are trying to get in and out of the job centre. So then we move on to Mr. Povey. Mr. Povey gives his statement on the same day of the incident, and he says he gives largely the same account as Ryan has given, so we won't go into too much detail about that. And of course, all this evidence, as I've already said, is on Chidgey File 1 on my website, which can be downloaded or viewed at in situ. So Povey says this in relation to his allegations that I've assaulted him. However, he, that's myself, kept waving his arms about, and I still had my palms up to stop him pushing past us into the job centre, but he punched me in my left eye. Well, you see, I mean, I'll just finish that. His left hand was clenched into a fist. I've said you've assaulted me. You will see at the first bit of the footage where he's put his hand up, and here's a photo now of a still from that bit. He's put his hand up there, so he is also claiming that the reason why my blows against him couldn't be seen is because it's off centre. It's off out of the camera range. But of course, his version of events is that he's only I've tried to hit him in order to get past him into the job centre, which would obviously presumably be the doorway of the job centre. So any hit that he's claiming occurred, in fact, occurred whilst he's pursuing me down the ramp. But of course, it never occurred. I never did actually hit him. That's a concoction. And of course, if he'd been punched in the face, in the eye, he wouldn't be just touching himself like this. You can see there's no movement back or any sort of ricochet from having been punched. I'm a large male. I'm a good 2 foot or foot and a half taller than Povey, and a good 3 stone, I would suggest, heavier than him. And I was, in my early 40s at the time, so I was physically very reasonably fit. And if I had punched a man so as to give him a black eye, as he was later claimed that I gave him, it would have been physically noticeable in terms of how, even if the punch itself had been off camera, in terms of how he fell backwards from the punch or moved in relation to that. So again, not much point in going over that at this stage. And moving on to Virtual Dick. He's the black male who can be seen appearing. He's sort of behind Povey and Ryan, with that not quite so active in repelling me. Virtual Dick says this: I'm currently employed by Securitas as a security officer covering for other officers who are on leave or off sick. Well, I won't read that, but it's a bit boring. On Monday, 3rd of August 2009, at around 2:30 to 3 p.m, I was on duty working at Job Centre Plus, Kent Street, Bedminster, Bristol. At this time, I was stood in the main entrance to the job centre with my colleagues Paul and Kevin. I did not know their surnames. Paul and Kevin had already explained that they had some problems with a male called Mr. Gray. I do not recall his first name. Paul and Kevin told me that Gray was banned and we were not allowing him to come in if he tries to. So you can see there already from the statement of Birchall the extent to which the violence is orchestrated, that they know that I'm going to try and come in and that they're going to use violence at the doorway to stop me coming in. And the violence that they're going to use is completely, there's no decision about what kind of violence they're going to use, if they're just going to be standing blocking my way or they're actually going to physically, as they do, push me backwards against the railings and so forth. So this is a pre-orchestrated act of violence that, of course, they could have avoided simply by calling the police, who could then ensure that the matter's dealt with peaceably. And bear in mind, I'm on bail for the alleged affray involving Walters a couple of weeks before. So all the more reason for the police to be involved in stopping any kind of altercation. Birchall Dick goes on to say, At this I saw Gray come into the job centre and locking his bicycle outside. Miss out that bit. So he then says, Gray was holding his camera up and holding his lens near our faces, and he was recording us. Well, I wasn't recording him because my point to make out, ladies and gentlemen, is that my camera I didn't switch it on properly when I went towards them with the camera. So the whole having the camera business was simply a bit of a red herring, because in my nervousness about being attacked, I forgot to properly switch it on. So he wasn't being recorded, so that's just nonsense, because he couldn't know whether it was being recorded, but he just assumed it was because I was holding the camera. Gray then started to try and push his way past me, Kevin and Paul, using his body, trying to force his way through. We kept explaining to Gray that he was banned and not allowed to come in. We kept standing back and raising our hands with open palms to try and stop Gray entering the building, but Gray kept trying to force his way in. Gray then started pushing Paul and Kevin and was calling Paul and Kevin a bald-headed idiot. Gray was constantly trying to push his way past them, and he started throwing punches with his right fist, as I think he had the camera in his left hand. On a few occasions, Gray tried to force his way in, and we had to push him back using force, and Gray was throwing punches again. This went on for about 15 minutes. Well, it lasted 5 minutes, if that, and again, the footage explains all, shows what in fact was going on. I'm not throwing punches. At no point am I throwing punches. You can see that there on the footage, and we'll come back to that, as I say, at the time of trial. Then Birchall Dick says, after the doors were closed, he didn't mention the doors being closed, but you can see in the footage the doors have been closed. But it seems to me that he's saying that after the incident has concluded, he says, Birchall Dick says, after Gray left, I noticed that both Kevin and Paul had a black eye, which they didn't have before Gray arrived. So Birchall Dick is claimed to have seen both Paul Povey and Birchall Dick with black eyes. Sorry, Paul Povey and Kevin Ryan with black eyes immediately after the conclusion of the incident. Now, we'll move on to what happens next. There's an officer involved, PC 1912 Earl Simon da Costa, who is the investigating police officer, and he will come to him in a moment, but he's attended the job centre fairly soon after the incident and made some inquiries. But before we deal with him, there is a visit to a nurse, Eileen Moran, who has given a witness statement herself for evidential purposes, i.e. the prosecution against me, dated the 13th of August 2009. Now she says this, on Monday 3rd of August 2009, I was at the walk-in centre on duty when I saw two patients who presented themselves at about 5 p.m. following an allegation of assault. Eileen Margaret Moran is a nurse, apparently, whose part of whose function is to record evidence of injuries to complainants in the form of Kevin Ryan and Paul Povey. She goes on to say, These persons were mistake Paul Povey, who informed me, there's a crossing out there where she says Kevin Ryan, and then she's put Paul Povey, who informed me that he was employed as a security officer at a job centre, and informed me that he had injured himself at work that day following him being involved in a scuffle. He described having been punched to the left side of his face. He informed me that he had not been knocked out, nor did he complain of sickness, dizziness, or double vision, but he did complain of mild headache and felt a little lightheaded and nauseous. He described lower back pain similar to a pain he had suffered from previously from an old back injury. I gave Mr. Povey a full assessment and suspected a soft tissue injury. I provided him analgesia, painkillers, and advised him to attend at the hospital emergency department if his symptoms worsened. I noted bruising to his lower left eye. I detected no bone tenderness. His eye was open. Following advice, he was discharged. So Moran claims to have seen some bruising to Mr. Povey's eye, which of course could have been inflicted by any means, and clearly the bruising isn't of any sort of significance for her to be concerned about anything. It's not swollen, for instance. His eye was open, and anyway, perhaps the second part of the statement is more interesting. She says, Kevin Ryan, Mr. Ryan, described he was also a security officer and had been involved in the same incident with the same assailant as Mr. Povey. He described having punched cross out, been punched or slapped, he wasn't sure which, in the face, and complained of a pain in the right side of his abdomen in the area of an old surgical scar. He complained of a mild headache. I completed a full assessment of Mr. Povey, she presumably means Mr. Ryan, and I did not note any visible head or facial injuries at that time. The tenderness to his abdomen was on his lower right side of his abdomen adjacent to the old scar. I suspected that the pain was due to soft tissue injury. I crossed out, provided analgesia, and advised him to see his GP if his symptoms worsened or did not improve. Following this, he was discharged. So she said she didn't see any visible head or facial injury, and this is sometime after 5 p.m. because she says that she began to see them at 5 p.m. So we then move on to back to PC da Costa, 1912 Earl Simon da Costa. Now, he was involved, he says in his statement, in the incident on the 24th of July. He was tangentially involved when I'm brought into custody and had the altercation with Police Sergeant Booker and some water. Now, da Costa says that he says that he became involved. I'll just read a statement, in fact. On Monday, 3rd of August 2009, at 17:29 hours, I was on duty in full uniform. At this time, I was at the job centre on Kent Street, viewing CCTV footage from an incident that had happened earlier. At approximately 1500 hours, whereby Ben Gray, who was banned from the site, attempted to gain access to the property, and in doing so assaulted 2 of the staff. The CCTV footage showed the 2 victims standing in the doorway as Gray shoved the camcorder in their faces and repeatedly attempted to push past them. At one point, I could see Gray lash out and strike one of the staff members. For most of the footage, Gray's head was out of shot. However, there was one part that you could see it, and I recognised him as Ben Gray, who I dealt with in custody the week before, 24/7/09, for a similar offence. Well, similar offence, albeit I wasn't charged with any offence on that date, as we know. In the footage, Gray was wearing a pale blue shirt, blah blah. At 1900 hours, after having taken a victim statement from Kevin Ryan, I took a series of photographs of the injuries that Ryan and Paul Povey had received. Ryan had a red lump swelling out of the right side of his face, and Povey had a black eye to his left eye, which was bruised. I later attempted to print out the photographs. However, the computer would not print off the photographs. So we have this injury to Mr. Ryan in particular. He's now got a red lump swelling out of, as da Costa claims, out of the right side of his face. this is at the time about 7 o'clock. So this injury, or alleged injury to Ryan's face, I should say alleged, obviously, in this context especially, because here we have the statement from Birchall, Birchall Dick, who claims to have seen an injury to Ryan's face and Pony's, but Ryan of most interest, at just after the incident, which is about 3:30-ish, according to most statements. So this injury that was visible to Birchall Dick at around 3:30 then vanished altogether when Ryan goes to see Nurse Moran at 5 o'clock, who actually specifically says she saw no injury to Ryan's face at all, and then the injury reappears miraculously to actually be a fully fledged swelling when it is photographed allegedly by PC DaCosta at around 7 o'clock, so within an hour and a half ish of him having seen Nurse Moran. And interestingly still, DaCosta's claim that he photographs the injuries, but the photographs themselves have mysteriously vanished in respect to the evidence that's then later supplied for the purposes of the prosecution. In any event, on the strength of this matter, and of course, just returning slightly to DaCosta, he also claims that he sees on the footage me lash out and strike, the words he uses, at one point I could see Gray lash out and strike one of the staff members. Well, we can't see that because none of the footage shows me striking out, and the trial itself agreed and will come to Judge Longman's judgment on when he finds me guilty of having assaulted both these officers by punching them or striking them in the face, that none of the footage shows me striking the officers. And this is, and indeed, there is no there's only one witness that claims to have seen me striking or trying to punch or hit one of the officers, or that doesn't necessarily see me making contact, but sees me striking out. And then that's a Miss Smith, who will come to, as I say, when we come to dealing with the trial itself, that where the Miss Smith reneged on her evidence that she thought she'd seen a strike, but having looked at the footage, she accepted the footage did not show me striking. So only in DaCosta's wild and concocted imagination is there any visible footage of me striking any of the guards in question. And of course, DaCosta ignores the fact that these two, primarily two, although Birchall Dick is slightly involved, although he's clearly less willing to get stuck in, but Povey and Ryan are going at me full throng, shoving me against the iron bars of the fence, where clearly it's not beyond the bounds of possibility that I could be substantially injured. They don't know whether I suffer from some heart injury, failure, or condition. Indeed, a lot of people suffer from those kind of injuries and don't realise it until they're subject to some sort of violence and they are the condition kicks in. And of course, that I could have easily gone head over heels in the back of the railings, and also other innocent civilians who are trying to get in and out of the job centre are also caught in the melee and likely to be injured as a consequence of the violence from the guards. But that's of no concern to DaCosta, even though DaCosta will know full well that they are carrying out a criminal assault. Even if force has to be used to prevent a crime, and I'm not committing a crime, let's try and concentrate on that. In any event, because just entering a job centre is not an offence as yet, as far as I know. I'm being flippant, but of course it's not an offence. But even if force can be used, it has to be proportional to what is being alleged. There's nothing in terms of my actions, even if I was committing some kind of theoretical offence, that would require that degree of violence to restrain me. Indeed, they either have to restrain me properly and then ensure that everybody is safe, including the person they're restraining, or they can't use the force. It can't be a sort of a rugby match, literally in the doorway of a public building, with a trial of strength between two individuals. And what if there were 3 or 4 of me? I mean, they're taking advantage of the fact I'm on my own, and therefore I'm easy to assault. Whereas if there had been 4 or 5, would they still have been able to be pushing us backwards and forwards in some kind of gruesome version of rugby? So in any event, that's all ignored by Da Costa, who then just simply ignores the violence that's been used against me, but claims that I have struck one of the guards on the footage, which it clearly doesn't show and was actually established to be the case. And both the assaults that were later claimed occurred when I'm down the ramp off the video camera. And of course, there's no way that at that stage, when I'm going down the ramp, that they're not pursuing me illegally, because we're now well outside the job centre anyway. But I emphasise that even at that stage, I did not strike any of the guards. So he then, going back to Da Costa's statement, he makes a further statement, because there is an inquiry, or the judge at Bristol Crown Court, that absolute monstrously corrupt and evil establishment, where every single judge that I've had contact with or even heard about, as far as I can make out, is horrendously corrupt. But in any event, they did feel obliged, or one of the pre-trial judges, I don't know who, if it was Judge Longman himself, but ordered, and probably wasn't, but in any event, it is ordered that Da Costa explain what's happened to the footage of not the footage, but the photographs of the injuries that allegedly occurred to Da Costa and Povey, that are taken at about 7 o'clock, i.e. about 4 hours after the incident, and of course after Moran has not seen any injury to Ryan's face at all. And he makes the following statement in a later statement dated the 9th of June 2010. So it gives you some idea of how long these proceedings have been going on. And he says, in my original statement, I mentioned at 1900 hours on Monday, 3rd of August 2009, I took photographs of injuries that had been received by the victims Kevin Ryan and Paul Povey, but that I was unable to print off the photographs from a computer. I took these photographs on a digital camera, and they were not printed off or transferred onto a computer, as I could not find the correct lead to link the camera to a computer. I have since looked through the camera in order to see if the photographs that I took are still on the camera available in digital format. However, they have not been retained. This means that they have been deleted from the camera, probably in order to free up some space on the memory card in order for more photographs to be taken. Although the photographs that I took are now no longer in existence, I did make a note of the injuries on the day that I photographed them. The injuries that I had photographed were a red lump swelling to the right side of Ryan's face and a black eye to Povey's left eye, which was bruised. Further to this, I would like to add that the photographs that I took were not intended to have evidential value. So basically what Mr. Da Costa is saying is that mysteriously this injury to Ryan in particular, that appears and disappears and reappears again, the photographs weren't even taken to be produced as evidence at some later date, so that in fact Mr. Da Costa can just invent having seen these injuries and would just take his word for it. By we, of course, we're referring to Judge Longman. He clearly would not be taking that approach if the allegation had been rape or some serious injury of that sort, serious assault of that sort, and it was going in front of a jury, because the jury would be less inclined to believe the word of the officer over the hard photographs taken. And the idea that they were taken not to have evidential value is, of course, utterly preposterous, and the line in of itself. And of course, this is just the final twist in endless footage and CCTV hard evidence that's disappeared. If we look at the list of footage that has disappeared, there's the footage of that's off camera of the incident on the 24th of July, the key moment where I'm attacked by Walters. That disappears, or wasn't seized, or wasn't taken by PC Marr, who was the investigating officer at that stage. The footage of my arrest, when again I'm arrested with great force and brutality after the incident with Walters on the 24th, that disappears. Then I'm charged, in fact, of assaulting 2 police officers whilst in custody, and indeed the alleged assault occurred over a dispute over CCTV footage camera pointed directly at the toilet, which I'm objecting to, and why I'm covering it up with tissue paper. And of course that isn't seized, that disappears. So that's 3 lots of CCTV footage. And then the final nail in the coffin is the photographs taken of injuries that I'm alleged to have inflicted on these 2 individuals, also go walkies. This is serial perverting public justice. The footage itself, just in relation to the incident from Walters, is a major act of perverting public justice. So, ladies and gentlemen, that is the part of the documentary that deals with the evidence that I say supports my allegations of criminal misconduct against David Chidgey and Judge Michael Longman. And of course, we'll come on now to this is the part of the documentary that deals with the trial and conviction at the hands of Judge Longman, and Judge Longman provided a copy of his judgment as to why he found me guilty of the 2 offences of common assault. I should explain a couple of issues just to clarify where we are so far. At the end of the last part of the documentary, I referred to PC DaCosta perverting justice by conceding the commission of an offence in terms of the photographs that he claimed to have taken of injuries that he claimed to have seen on Ryan and Povey. Perhaps I've got that slightly wrong, because of course he's not concealing the commission of an offence by deliberately, as I would suggest, deleting photographs that he probably never even took. He's claiming to have taken photographs that, of course, then bolsters his general agenda, which is to make a false allegation of criminal assault against Ryan and Povey. So he's more perverting justice by making false allegations, and the authority comes up here just to confirm that. Also, I should just explain that the trial process, or the criminal process for summary offences, is different from the ones that most people are familiar with indictable offences that then go before a jury, or the triable either way offences where the defendant can elect to go in front of a jury if the prosecution wants to keep it in the magistrate's court. The type of charges, the common assaults that I was alleged to have perpetrating against Ryan and Povey, they are specifically summary offences and are dealt with only in the magistrate's court in the first instance. And if the defendant is unhappy with the conviction, he can then ask for a retrial at the Crown Court by appealing to the Crown Court, which is what I did in relation to the conviction that was carried out against me at Bristol Magistrates Court. And I won't go into the details of the trial at Bristol Magistrates Court, not least because what's important is the Court of Record, which is the Crown Court, and where everything is recorded, so there's no dispute about what's occurred. And the proceedings are supposed to be a bit more correct, but as you shall see, they're anything but. So before I should also just point out that at the time I come to trial in July 2010 before Judge Longman, I'm in custody in terms of another stitch-up, another concocted criminal proceedings, and I won't go into those at this stage because it would simply confuse matters as to why I'm in custody. But suffice to say, and I should also mention that in the magistrates court, I was given I think a 36-week custodial sentence. I think he activated he gave me a suspended sentence anyway, the judge, and I can't even remember his name off the top of my hand, who the district judge was who convicted me. But I wasn't convicted. I wasn't sentenced to custody. I was sentenced to a suspended sentence on the basis of the common assault charge. But anyway, we're now at the stage where I've appealed it. I'm in custody, so I'm in cells below the cells in Bristol Crown Court are all obviously in dungeons, effectively down below ground, and I have managed to recruit get representation from M&M solicitors who are based in London. And a solicitor from London has turned up, because no solicitor will represent me anywhere in the Western Circuit, even as far back as 2010. So I'm and they in turn have got a barrister to represent me. M&M's have got a man called Gareth Graham, who at the time was a barrister working at Albion Chambers. And he turned up in cells. I had no communication with him until the day of the trial. I've got no real. I've had a very brief conference with the solicitor from M&M's, and so I'm supposed to prepare for my trial on the day of the trial, and prepare and agree with the barrister all the relevant questions and the points of law that I want the barrister to submit on my behalf to the judge. And of course, I'm put under huge pressure because not only am I in custody, but of course the trial is about to start, and I would suggest already my Article 6(3) right to be have adequate time and facilities to prepare for my defence has been destroyed because I'm not given. Clearly on the day of trial is not the best time to be preparing for how the trial should proceed. In any event, this is all by the by because Gareth Graham only turned up long enough to say goodbye because he wasn't going to represent me after all. He claimed that he had been led to believe by M&M solicitors that the trial was only going to last 2 days, and in fact the trial is listed by Crown Court as 5 to 6 days. He had to leave, or he gave his excuses to Judge Longman, and Judge Longman said, "Oh, fine, bye." And I was then supposedly having to wait in cells while the solicitor, this was Judge Longman's directions, had to then find another barrister to represent me, and clearly no barrister would represent me because that's why I had to go to London to get a solicitor. And clearly, Gareth Graham was just simply part of the general wall of corruption of barristers that are washing their hands of me. But in any event, I decided to elect to represent myself because it would just simply be less traumatic than waiting for a barrister who, even if one was found, I would then have to try and prepare for my trial, by which time it was already one day of the trial had already evaporated, and of course this is a huge public expense to the public because the public are paying for all these members of staff from Bedminster Job Centre to be waiting to give evidence. They're all having to be catered for by the people that deal with witnesses in cases. I'm being kept in cells and having to be attended on by jailers and so forth. So the process by which, rather than prepare for the trial with a barrister weeks before the trial begins and then go straight in with the trial or make all representations and then the trial, is for nothing. And the judge himself is simply being paid by the taxpayer just to idle away the hours whilst I'm supposed to be trying to find a barrister. So anyway, cut a long story short, I'm representing myself. However, so the judge's first ruling that he made was after I made representations that the trial was completely illegal, the technical term being an abuse of process. There was clearly major illegalities in the whole proceedings, including, of course, we've mentioned DaCosta's missing photographs and CCTV and so forth. So the judge ruled on abuse of process, but before he went into my submissions on that, one of which included the issues over representation, Judge Longman states this. At the outset of the appeal, Mr. Gray was represented by solicitors and counsel. The court was told that counsel was unavailable for the latter part of the trial because he had been instructed on the basis of a time estimate of 1 to 2 days. In fact, the time estimate on which the basis the court was working on was 5 to 6 days. Accordingly, the instructed counsel had to withdraw, and the court gave Mr. Gray an opportunity of seeking alternative counsel, but that opportunity was not taken, and he now represents himself. I say in parenthesis that although, of course, this is an extremely important case for Mr. Gray, in essence it is not a particularly complicated case, and in the court's assessment a great deal of time would not have been required by counsel to take instructions and marshal the necessary arguments. Well, a number of points here. I mean, to begin with, I made inquiries of my own or complaints of my own about why the firm that had agreed to take on my case, M&M Solicitors, had given Mr. Graham the incorrect time estimate of the trial, which then gave Graham the opt-out not to represent me. This, in fact, was responded to by M&M solicitors in the first place, and that they wrote to the court and to myself after the fact to explain that in fact they had told Mr. Graham, Mr. Graham's the lady that deals with from Chambers, Mr. Graham's chambers at Unity Street Chambers, which is a sort of a kilometre away from Bristol Crown Court, and that is dealt with by a clerk, and I think her name is mentioned. But I'll read from the paragraph from Eminent Solicitors that explains why Mr. Graham, their version of what they say was the truth, and I would suggest clearly is the truth, which was that Mr. Graham was clearly told that the trial would last 5 to 6 days as agreed with the court. And the solicitors say this: on the 29th of July 2010, we spoke to Unity Street Chambers, Bristol, who informed us that they had a barrister by the name of Mr. Gareth Graham, whom was available. Our clerk, Hetal Patel, liaised with Claire Wadden of Unity Street Chambers. Claire Wadden is the clerk who liaises between the barrister and the solicitors who want a barrister. Of Unity Street Chambers in regards to instructions. The clerk at the Chambers was made fully aware that the appeal had been listed for the duration of between 5 to 6 days. However, in an attempt to secure a barrister for the hearing, we had contacted several chambers, including Albion Chambers, who were Benjamin Gray's former barristers. I don't think they were. I think this is just complete fabrication because, of course, David Chidgey is from Albion Chambers. He was the prosecutor. It would be unlikely and probably inappropriate for me to have a barrister from the same chambers, and I certainly don't recall having any barrister from Albion Chambers. Indeed, I didn't even have legal representation from a solicitor until a few weeks before the trial. But in any way, we were informed by them that the appeal would realistically last for approximately 1 to 2 days. We conveyed all of this information to the clerk at Unity Chambers, but they were also aware that the matter was listed in the Bristol Crown Court for the duration of 5 to 6 days. They were also made aware that the prosecuting counsel, that's Mr. David Chidgey, would be unavailable on the 6th of August 2010, as per the letter we received from the court, and therefore the court would not be sitting on this particular day. Miss Wadden was fully aware of the court's listing of this matter, and it was agreed that Mr. Gareth Graham would take on the case on that basis, rather than the basis of a listing of 1 to 2 days. So the firm insists absolutely that Graham was told that the trial would be lasting for 5 to 6 days, and indeed they pointed out that they referred the Chambers to a letter from Albion Chambers from Mr. David Chidgey, who had submitted a position that he wouldn't be able to attend the trial on the 6th of August as he was otherwise engaged, but the 6th of August was of course a week later than the date of the trial date, the start of the trial date at the end of July. So they had clear glaring evidence that the Chambers was well aware of the 5 to 6 day time estimate, and that 1 to 2 days was simply a hope or a suggestion from Albion Chambers, which is the prosecuting counsel, and therefore had their own agenda. But the Unity Street Chambers responded, and they said that it was, as explained in my early response, I'm quite satisfied. This is the head of Unity Street Chambers, who insists basically I'll just read a brief bit of the letter dated the 14th of January. It was in response to this that M&M notified Miss Wadden that the case was unlikely to last for longer than 1.5 days, and such that the formal time estimate was wholly inaccurate. You'll recall the lack or any timely, full or proper instructions, such that the counsel was himself unable to make any alternative assessment, and such that he and Miss Wadden were bound to rely on information provided by M&M. M&M elected to instruct counsel on your behalf, this is the letter to me, and in the full knowledge that he was only available for 2 days. So, I mean, the point here, of course, returning to Judge Longman's ruling and position on the matter, he could not care less who was telling the truth. He made no inquiries as to whether Mr. Graham should properly be allowed to recuse himself, which is the formal technical term for withdrawing from a case, on the basis that he simply was told the wrong information by M&M. If I was to go with what Judge Longman wanted me to do, I had to stay with M&M, having been incapable even of telling the truth about the length of the time estimate of the trial being 5 to 6 days to Unity Street Chambers and Gareth Graham. So Judge Longman is expecting me to stay with this firm, having severely found them wanting in terms of them being unable even to instruct the barrister as to the basic fact of the length of the trial. So how could I possibly have confidence, and should I be expected to stay with that firm if Judge Longman's position is correct? Moreover, it's quite clear that Judge Longman is that Gareth Graham's information to Judge Longman is completely fabricated. There was clear evidence, and the M&Ms were able to provide it in the form of correspondence from David Chidgey about not being available on the 6th of August, proving that in fact Gareth Graham was well aware that the trial was time estimated for 5 to 6 days. He'd agreed to take on the case, and he was made fully aware that the case may well last 5 to 6 days, and it was Gareth Graham who therefore should not have been allowed to withdraw from the case certainly without any proper inquiry from Judge Longman. Judge Longman makes no inquiry. He attacks the credibility of my solicitors without any basic understanding of the facts or who was telling the truth about the 1.5 to 2 day estimate that Gareth Graham claimed was the only information he knew about the trial, whereas the Crown Court itself and M&M and Albion Chambers had all agreed the trial was likely to last 5 to 6 days, which in turn turned out to be the case. So that is a flavour of how corrupt Judge Longman is in terms of him washing his hands of a barrister, or allowing the barrister to wash his hands of me, hanging me out to dry, leaving me to rot in cells, whilst I'm expected to stay with the solicitors who Judge Longman has attacked in no uncertain terms, even in terms of being able to provide the correct information about the length of the trial. That is a flavour of how sinister and vile this judge in fact is. And when he goes on to say, I say in parenthesis, he talks about the trial, Judge Longman again. He says it is an extremely important case for Mr. Gray. In essence, it's not a particularly complicated case. Well, the judge isn't supposed to know and comment upon the substance of the evidence before the trial has been is underway. The complexity of the case is, obviously, it's not as complex as a ridiculously convoluted tax evasion trial would be, or some matter of that description. And indeed, special judges have to be appointed for those kind of trials because they're so complicated. But it is complex in terms of the endless slew of contradictory evidence and evidence of major corruption and criminality against the police officers involved, and David Chidgey himself, and of course the job centre staff. There's 2 incidences. They're obviously traumatic for me, and that is another reason why I would need to be represented if I'm making counter allegations of egregious assault. And none of that is of any concern to Longman. He starts commenting on the simplicity of the case before it's even been heard. When in these kind of proceedings, in summary proceedings, the judge isn't even supposed to have the evidence or the statements in front of him, which is supposed to be adduced as the case unfolds. And of course, it's not just about the complexity, as I say, it's about the sensitivity, and the issue is that I'm having to question these witnesses without any, directly, without somebody who is professional, able to intervene and be more neutral about the process. But anyway, as I say, that's just a flavour of what I'm in for in terms of the trial itself, which then goes underway because I'm now representing myself, Mr. Graham being allowed to sail off into the sunset. And of course, Mr. Graham, no inquiries have been made or any evidence has been made to find out if Mr. Graham actually had other alternative counsel. And Mr. Graham, if you go on his website, Gareth Graham, I forget off the top of my head which chambers he now is with. He doesn't have any experience with criminal law. He deals with financial crime, I think, for financial matters mostly. There's no mention of him being as a criminal barrister. And of course, what did he do when he left the courtroom on the day he did? Did he get legal aid for his brief appearance? And finally, I should point out the legal ombudsman, who then investigated the conduct of Mr. Graham and M&M Chambers, both said that both came to the same conclusion that both chambers and the firm had acted, had not provided a poor service to myself, even though Gareth Graham simply turns up long enough to say goodbye. Both the firm and the chambers give completely contradictory information about the information that they gave each other prior to the trial itself, which was their excuse for neither of them effectively ending up representing me. And despite the fact they both gave completely contradictory stories, they were both found by the Ombudsman to have been, without reproach and coming out smelling of roses in terms of the quality of service. I mean, the finding that Gareth Graham offered me adequate service when he simply left me high and dry in a cell and only turned up long enough to say goodbye, again is the flavour of how the corruption of the Crown Court and the barristers involved with it, and then the police officers, and then filters down and infects every other kind of institution that's supposed to be independently investigating and holding these types of individuals to the highest standards and account. And it just, as I say, it filters outwards in terms of which is the nature of corruption generally, is it not? I think we can agree. So we come to the judgment of Judge Longman in the case after trial. And of course, what is heard and said through in the trial itself it will be referred to as we come to the judgment. Now, of course, the first issue is Judge Longman's dealing with what happened on the 24th of July. And he says this at paragraph 4 of his judgment. As for the respondents in this case are the CPS, just to clarify that, I'm the appellant and the respondents are the CPS for future reference. Judge Longman says this: as far as the respondents are concerned, the incident on the 24th of July was relevant by way of background only, to explain how it was that the appellant came to be banned, as they say he was. Some witnesses who gave evidence in support of the charges were also present at the earlier incident, and we allowed evidence to be given in respect of 24th of July as being relevant to the credibility of those witnesses, who included Mr. Ryan and Mr. Lisi, the job centre manager. And we also considered the evidence relating to the 24th of July in relation to Mr. Gray's contention that this case was an abusive process on which we have already ruled. Well, the abusive process argument is there in my in Chidgey file 1 on my website, bristolspotlight.tech. And it would be too complicated to go into, or too long-winded to go into the abusive process. But the same issue stands anyway, because my complaint is there was glaring evidence of major criminal violence from Walters, witnessed by Elizabeth Evans, in terms of his strangling me, and in terms of the glaringly perjured evidence from the other parties from the job centre staff, which including, of course, the police officers, which led to my being arrested and then tortured at Southmead Police Station. None of which is of the slightest bit concern to Judge Longman. Judge Longman hears evidence from me. He's received my skeleton argument for the abusive process before the trial has even begun. But then once the trial is underway, he's heard evidence from me directly. I've had to relive the terrifying ordeals of the 24th of July, but that's all the mention he has. When he actually says that he accepts that collectively him and the two lame magistrates who sit either side of him, who are effectively puppets of the judge, they will never, I should imagine, go against what the judge says. But be that as it may, the judge has accepted that he's going to consider it as evidence relevant to the credibility of the witnesses from the job centre, but he does not do that. You will see as the judgment unfolds. I won't read every single word of the judgment, so you can of course clarify it online if you want. But that's as far as he concerns. Indeed, we shall see he goes into a lot of the evidence that the prosecution witnesses, the job centre staff give, but then whitewashes in what way I've attacked their credibility and have provided evidence that they're actually perjuring themselves hand over fist. But he's made it quite clear he's not interested in any criminality that is right under his nose in terms of the evidence of the 24th of July, which we will see. We've seen the attack from Walters. We've seen the one attack that is shown on the video. We've seen the evidence of Elizabeth Evans in terms of the earlier attack. As I say, that's if I'm attacked, effectively Judge Longman is saying that's fine. Anybody can attack and injure me, and that goes with that will simply be a blind eye will be turned by one and all in respect to that. But of course, if the security guards are complainants, that's a whole different story. Then we'll have a full Crown Court trial. I will be deprived of legal representation, and Judge Longman will stitch me up like a kipper every which way from Sunday and absolutely collude in the most heinous, vile and venal criminal offences you can imagine, short of actual murder. I mean, bearing in mind that we've come close to murder when Walters has grabbed me round the throat in the first incident of the 24th of July. But so we'll just move on to the judgment. He then goes on to say, in fact, Judge Longman, in paragraph 5, we emphasise, however, that the real issue in this case is whether the appellant hit the complainants as alleged on the 3rd of August, and if so, whether he may have been acting in lawful self-defence. Well, of course, that's only because the judge decides in cahoots with Judge David Chidgey, that any violence towards me, and of course terrorising the other members of the other users of the job centre into the bargain, is of no interest to him at all, whether it's the 24th of July or the 3rd of August, as we shall see. So moving on. Judge Longman then goes on to list the evidence from the various parties and what they say about the incident. He says, paragraph 12, Paul Povey described how they stopped Mr. Gray coming in and he tried to barge past them. He pushed them and they pushed back. He said that Mr. Gray punched him in the left eye, then assaulted him again by punching him in the eye. He said that his eye was bruised as a result. In the cross-examination, he conceded that when he made his written statement the same day, he referred to one punch only. Judge Longman then refers to one of the witnesses, Karen Rockash, who I may be wrong, but I think she's the woman that talks to Ruth Lacey, slightly larger woman than Ruth Lacey, and I think I refer to her. We can see her a little bit standing quite well back of the melee that's going on in front of herself and Ruth Lacey. She says, apparently paragraph 15, Judge Longman says this, Karen Rockash described Mr. Gray hitting Mr. Povey in the face. Mr. Gray attempted to push past him. She said it looked as though he hit Mr. Povey in his eye with a fist. She saw no movements and believed that one made contact. She saw two movements and believed that one made contact. Ruth Lacey described Mr. Gray lunging forward with one arm, and she could see that he was making contact with the guards. In cross-examination, she said that she knew that contact had been made because the guards were pushed back into her. Karen Rockash, who's another individual, and maybe I've got she's the same individual, beg your pardon. She says, as we've referred to at paragraph 15, Karen Rockash said in evidence that she saw Mr. Gray's fist hit Mr. Povey. She was viewing from a distance of about 5 meters. Mr. Povey was just outside the door and she could see Mr. Gray from where she was, even though from the viewpoint of the CCTV camera, he was around the corner. Well, I mean, just in reading those brief paragraphs, we know from the footage, if nothing else, that Judge Longman is referring to what must be patent concoctions from the various so-called witnesses. Of course, all these witnesses, I mean, it was Ruth Lacey who instigated the fight to begin with, so she's hardly an independent witness. Rockash is a junior colleague of Miss Lacey and a colleague of Ryan and Povey, so she's not an independent witness. And obviously what they're saying is utter rubbish. I mean, the fact that Ruth Lacey interpreted that she had seen me hit Povey from the fact that there had been movement and because the contact had been made is utterly preposterous. She hasn't actually seen me hit anybody, and she, as we can see from the video, has a ringside seat. She's right just behind, for the most part, Ryan and Povey as they're attacking me in the doorway. So she has the ringside view of what's going on, and she doesn't see me hit either individual, and because she doesn't see me hit anybody, she extrapolates from the fact that there has been contact between the two of us, which is a preposterous position to take, considering that the two guards have made up their mind to stop me coming in by use of physical force, firstly by blocking my way, but then by using major force against me, including shoving their hands right into my face, as you can see Ryan doing almost constantly, So it's them that are making contact with me. They've made a conscious decision to come to the doorway and make contact with me to prevent my what I protest is perfectly lawful, i.e. non-criminal attempt to enter my own job centre, i.e. the job centre that I'm supposed to be enlisting at, and moreover to obtain evidence of the camera. Of course, Judge Longman, as you can see from his assessment of the why I'm going into the job centre, he erases from any mention the fact, as we've heard, even from Povey himself, and I think Ryan, who mentioned the fact they hear me calling the police before I've entered the job centre. So I've tried to get the involvement of the police myself. As I say, there may be evidence also that the security guards did the same thing. I think they did. And the police don't turn up. That's the first point. And of course, I want to record where the camera is in terms of the camera footage of that's not seized by the police of the attack by Walter. So I have a perfectly legitimate reason to enter the job centre, which of course, even if I was doing something improper, should have been at the hands of the police to intervene and to prevent any public order incident. If not to protect me, then protect the guards, bearing in mind, of course, that I'm on bail because I was being investigated for attacking Walters or for a part of an affray involving Walters only a few days before. So I'm on bail. And I've contacted the police myself, and the police are clearly instigating the violence by refusing to intervene either on my behalf or on behalf of the job centre staff. And so obviously any mention of contact is utterly meaningless and is not evidence that I have hit anybody, which is the key point. And in terms of Rockhatch's evidence, well, she says the evidence that he describes her giving is that Mr. Povey was just outside the doorway. Well, we can see that at the time that he says he was hit, which is clearly the point where he's touching his face like this, is I'm down the ramp. And there's no way that from the position that Rockhatch is standing, she could have seen round the corner of the blow to Povey had it occurred at all, because we have the same angle as Miss Rockhatch does in terms of the point of view that we have from both her and the CCTV camera. There's another witness, and this even, I hope you agree, will take the biscuit, but I try not to pass comment myself. At paragraph 18 of his judgment, Judge Longman says Karen Smith described Mr. Gray trying to push past the security guards. At one point, she says she lunged at Paul Povey and punched him in the face. Well, that, ladies and gentlemen, is an utter concoction, because during the questioning of Miss Smith by myself during trial, Miss Smith looked at the footage that we've seen of the doorway, and having looked at it, she accepted that she had been mistaken in terms of seeing me hit anybody. She accepted that from the footage I hadn't hit anybody in the footage, and that she had been mistaken because of the angle she was at, bearing in mind she's not even visible in the footage, so she's back even from Miss Rockhatch and Miss Lisi, so that she's got two layers of human beings before she can see anything, and she's not 7 foot tall. She's I think slightly, she was about the same height as Lisi and Rockhatch, so there's no way she could have possibly determined somebody being hit from that far back when it's not even shown on the CCTV footage. And she accepted that, and she accepted that she got it wrong under oath. And I even mentioned this at the end of the proceedings and asked Judge Longman if he would not at least correct that mistake in his judgment, because Miss Karen Smith had accepted that she hadn't seen me punch anybody, and he refused to do that. But he did agree to order a transcript of the point in proceedings where Rockhatch had been questioned by me and conceded that she hadn't seen anybody punch anybody. So this is a judge who is quite prepared to convict an innocent man, presumed innocent in the eyes of the law anyway, even if there's any doubt about whether I did actually punch these individuals, and even if I did punch them, whether I was acting in self-defense or not. And of course, that's another whole area of law. which we'll come to in the judgment. But in any event, there's one. Miss Lucy hasn't seen me punch anybody. Miss Smith hadn't seen me punch anybody because she agreed that. Rockhatch claimed to have seen me punch Povey when if I punched at all, it was when Povey was round the corner, even though she said he was stood in the doorway. And as the final sort of nail in the coffin of all this, even when a witness has conceded that they got it wrong under oath and stated under oath that they did not see me punch somebody, Judge Longman says, "Oh, I'll get around that by just lying about the evidence she gave and say that she actually saw me punch somebody." Punched him in the face, she says, very specifically a punch. Of course, even if she had seen it, how could she possibly have done, being 3 rows back behind 2 sets of individuals when it wasn't even visible with the CCTV that we've looked at. In terms of Povey's evidence himself, Judge Longman says at paragraph 19, Mr. Povey is shown on the DVD holding his face as if he has been hit there. And the audio tape of the incident, as recorded by Mr. Gray, records Mr. Povey saying, at about that point in the incident, although we have not found it possible to synchronise precisely the DVD and the audio tapes, "You assaulted me, mate, right in the eye." So what Judge Longman is confusing is the allegation or the complaint with evidence that it has occurred. Clearly, if what the Povey and Ryan are trying to do is trump up a charge that I have hit them illegally, presumably, provided they could get round whether or not they're attacking me to begin with illegally and carrying out a criminal assault, which they clearly can do with their relationship with the Southmead corrupt police officers there, and indeed, as it turns out, David Chidgey and Judge Longman, then they still have to prove the blows have occurred. And clearly to do that, all they have to do is touch their face and look at the camera and go, "Oh, we've been hit," and make sure that their complaint occurs when it's off camera, when clearly if they're using, even if they're using legal force at the doorway, the cannot force then extends and is allowed to, in terms of pursuing me down the ramp. And of course, but in any event, that is Mr. Povey saying that he has been hit. It's not proof or evidence that they've been hit, because if that was evidence, then of course any complaint of any criminality would just simply, you do away with the evidence that somebody has committed the crime or not and just look at the complaint that they have committed the crime. But in any event, Judge Longman then goes on to point out that Miss Moran claims to have seen some bruising around Povey's eye, which of course is hours after the incident, and he could have inflicted himself if he's, as he clearly is, desperate enough to trump up a charge against me, and of course at the same process exonerate himself and his colleagues from any illegal violence towards myself. And they just say, well, having considered all the evidence, we are sure that Mr. Gray did punch Mr. Povey in the face at least once, causing an injury to his eye. We accept that the evidence of the job centre staff. We accept the evidence of the job centre staff, and although the view from the CCTV camera is imperfect, find that it gives some support to the evidence of the witnesses. Well, how could it done? Because at no stage in the footage am I seen punching either Povey or Ryan. So how can it give some support? It either supports me having punched them, or it doesn't show that I punched them. If the punch happened off the camera, the CCTV is irrelevant, isn't it? It has no consequence at all. And if it happens in front of the camera, then there would be no need for the trial. I would have admitted to punching them, and we could go straight on to whether or not they had lawful, whether or not they were attacking me and I was acting in self-defense. So how it's helped them, given that it contradicts all the evidence, that evidence that says that, from some witnesses, that clearly, certainly Miss Rockhatch in particular, who claims that they've seen me punch them when it was clearly she was asserting that it had happened in the doorway, which is why she could see it. But in any event, we do not accept, Judge Longman goes on to say, we do not accept that that Povey has invented the allegation, which was made first at a time when he must have considered it at least possible that what had happened was recorded by the camcorder which Mr. Gray held throughout the incident. Well, no, because of course it was established by the time the matter had come anywhere near being considered for a prosecution. that my recording hadn't transpired. When I was arrested on the night of the incidents, bang, bang, bang on my door by DeCosta and Botley, I think he was, his colleague. Of course, they asked for the camcorder, and I can't remember if I provided it to them, but I said it wasn't recording, and it hadn't recorded because in my nervousness, I hadn't put it on properly. For a start, Poe, if we can clearly see from the 24th of July incident that the police from the Southmead police station, the local police station, are in cahoots with the job centre staff, that the job centre staff are getting a green light in terms of attacking scumbag dole scroungers, or sort of clearly relegated in society to the very lowest in the food chain. So they know how corrupt the Southmead police station is, and if it turns out that the footage exonerated me, then of course just with the incident with Walter's attack, the footage would go disappeared, or they would just simply refuse to continue with the investigation. But of course Judge Longman completely whitewashes and colludes in and connives in all the corruption and criminality from the 24th of July and the August, as we should come into, because we haven't even obviously canvassed the disappeared photographs and the injuries that appear and disappear and reappear with Ryan. And also, of course, in a melee, when there's a sort of a fight going on, to put it in the most neutral terms, Povey he's well aware that I could have struck him with my free hand and it wouldn't be recorded, and he can still complain that the footage wouldn't show it. Anybody of course, Judge Longman, living in Judge Longman cow cuckoo land, perhaps himself hasn't been involved in any situation where he's had to record a fast-moving, violent incident when you're right in the middle of the affray. But it's self-evident that if a recording device in that nature, where it's so close up to the altercation, it's not going to capture every single incident as the camera from a distance would be. And of course, it's almost certain that there was a CCTV camera outside the front door as well. I'm guessing on that point, but what you need is a bird's eye view of the incident, or something from a distance, because when you're right in the middle of the incident, you caught that the footage, the camera is going to be moving about along with the rest of your body, and therefore is not likely to capture a brief incident. Of course, Povey has claimed that he's been hit on his left eye, which would have been the right position for if I'd swung at him with my right fist. But of course, I'm holding the camera with my fist, and Povey complains that I've hit him with my hand or my fist when I make contact with him, which of course would have mean that it would have been a left hand blow to his left side of his face. So it wouldn't have really been a punch; it would have been more of a backhanded slap. But in any event, whatever force was used to create a black eye was not shown on that footage, because as we've already established anyway. But but for those two reasons, Judge Longman's rubbish about Povey being afraid of making a false allegation if it wasn't proven by what he thought was a recording device that I was holding it needs to be seen in the context of what happened to all the other footage of all the other violence that occurred to me involving the job centre staff and police earlier. So then Judge Longman turns to Ryan, having found the evidence proved in terms of Povey's complaint. Turning to the alleged assault on Mr. Ryan himself told us that Mr. Gray struck him in the face to his right eye with some force. He said that he told Mr. Gray that he'd assaulted him, and he said that Mr. Gray hit again in the same area, causing a black eye and a swollen eye, which came up later. Mr. Povey testified that Mr. Gray slapped Mr. Ryan across the face and then punched him. Mrs. Rockatch said she saw the appellant slapping Kevin Ryan on the side of his face several times with some force. She conceded in her written statement to the police, she described it as a tapping. She said that what she saw was hard enough to cause the injury which Mr. Ryan had, and that what she saw would not be visible on the CCTV because it took place around the corner. So now she, in fact, we can see nothing in anywhere in Ryan's body language throughout the incident of the video that would indicate that he's been hit or hurt in any way. And of course, again, Rockatch has supernatural powers. She's seeing round the corner to areas that the camera can't see, and she's seeing me hit both these officers, which nobody else, other witnesses, could have seen or would have been shown in the camera. It would have been shown on the CCTV footage. Jessica Brown, she's a witness that I hadn't taken any note of, hadn't been mentioned before now, certainly in relation to Povey. Jessica Brown, who did not see the whole incident because she was dealing with customers, described Mr. Gray barging into the security guards as he tried to get through the building. She said she saw his hand fly up in the air and Mr. Ryan's head moved to the side. Mr. Ryan said, that's the second time you've hit me now. From that, she inferred that contact had been made. She too said that the view she had was better than the CCTV. Well, it can't have been better than the CCTV because the CCTV didn't catch any evidence of a hit on the basis that the complaints of the hit, but from both Ryan and Povey, were round the corner and therefore behind a wall. So again, how could Miss Jessica Brown have inferred anything if she hadn't actually seen, if she wasn't able to see, presumably, through the brick wall that divided her from the altercation that led to the alleged hits? So, I mean, that's the assessment of the evidence from Rockatch and Karen Brown, etc. Well, unfortunately, the audio tape, the tape that I had of the, I had a dictaphone recording the incident as well, which was switched on and the police also seized. And unfortunately, I can't find that, being a decade ago. But Judge Longman refers to the footage or what's heard, and he says again, at one point, a voice referred to in the transcript as that of Mr. Povey said, "That's twice you've done that, that's assault." Mr. Gray then says, oh, you think you can jab me in the ribs? Mr. Ryan said in evidence that he told Mr. Gray that Mr. Gray had assaulted him, to which Mr. Gray replied, "What, you've assaulted me by hitting me in the ribs?" We find that the transcript is wrong in attributing the remark to Mr. Povey, and that it was in fact Mr. Ryan who could be heard telling Mr. Gray, "That's twice you've done that, that's assault." Again, I mean, what relevance does it have if they just the fact that they've complained of being assaulted is not proof that they have been assaulted? And Judge Longman is clearly muddling up again, as with Povey, the difference between somebody accusing somebody of doing something and somebody actually having done the thing that they're accused of. Of course, if Judge Longman could, he's doing himself out of the job and doing the whole criminal justice system out of its major function, which is to distinguish the innocent from the guilty, because the trial process is obviously to weed out what evidence there is to support the complaint, not to establish that there has been a complaint, because of course we know there's been a complaint, because otherwise there would not be a prosecution and trial. So anyway, Judge Longman goes on to say, paragraph 27, different witnesses say that they saw an injury to Mr. Ryan's eye after the incident. However, when he attended the walk-in centre to be examined by Nurse Moran, he had no visible injury. A photograph taken the next day shows him with bruising under his eye. In the course of his evidence, Judge Longman goes on to say at paragraph 28, Mr. Gray told the court that he did tap Mr. Ryan lightly on the cheek in what was an instinctive response to being jabbed hard in the ribs. He maintained, however, that he did not hit Mr. Ryan as alleged, nor did he cause the injury seen in the photograph. We accept that if that was all he did, even if that were technically capable of amounting to an assault, it would not constitute the assault with which he is charged. Having considered the evidence in relation to the alleged assault on Mr. Ryan, however, we are satisfied that Mr. Gray did deliberately strike him in the face and that he did so hard enough to cause the injury which is seen in the photographs. Judge Longman goes on to say at paragraph 30, we do not know how it was that the injury, which was visible to others, was not visible to Nurse Moran. Whether it had not yet developed, and the witnesses who saw it did so later, or whether the initial reddening had gone before the bruising appeared later. Well, again, this is Judge Longman simply getting around any inconvenient obstacle to finding me guilty by lying in his crooked teeth. The evidence that was given by all the witnesses that said they saw an injury to Ryan and Povey were, well, the two witnesses that I'm aware of, which was Ruth Lucy and Birchall Dick, both of them said, both under oath and in their witness statement, that they saw it immediately after the incident. Clearly, that evidence was to support the evidence, given that there was no other evidence in the form of CCTV footage, etc., that I had hit them during the altercation. And of course, if they had seen the injuries the day later, that would not be evidence that that it was me that necessarily caused the injuries, because they could have just bopped each other on the eye and said, we're going to attribute any bruising that comes up to Gray after the fact. So, and in any event, it was quite clear and specific from the two witnesses that claimed to have seen marks on Ryan's face that it was immediately after the incident and before Ryan attended Nurse Moran's meeting. So he's concocted that in order to get round the preposterous evidence that Ryan has an injury, a red marking to his eye, just after the incident with me, or as a result of the altercation with myself. Then it disappears altogether when he goes to see Moran, and then it's swollen into a full-fledged, fully blossomed bruising and red eye and even swelling when it's in front of Da Costa, whose photograph, and of course what Judge Longman doesn't mention, of course, is the missing photographs of the injury that night, which might have given some weight to Ryan having received the injury from myself. But of course, it would not explain how two witnesses have claimed to have seen it before Ryan has even seen Moran. And no jury, of course, in my view, and hopefully in your view as well, viewers, would believe that Ryan had an injury seen by Lucy and Birchall Dick, but was invisible to Nurse Moran, and that those two witnesses were not perjuring themselves and not lying about having seen that injury. In any event, let's move on, because they simply say, he goes on to say that he and his colleague lay barristers, lay magistrates, are sure that this bruise that was later photographed, I think 2 days later, not a day later, as Judge Longman says, and which I haven't got at the moment to put on the footage, to put on this documentary, but he's convinced. He just clarifies that it's definitely me that's caused that bruise that was later photographed. Again, I think by Da Costa. Judge Longman goes on to say at paragraph 31, there were no independent witnesses to the incident who gave evidence. All the witnesses were employees at the job centre, although independent witnesses were present. We do not conclude from that the police have been selective in choosing only witnesses whom they believe to be impartial, or do we find... we do not conclude from that the police have been selective in choosing only witnesses whom they believe to be impartial. It doesn't quite make sense, because of course my complaint was that the police have chosen only witnesses who are partial, not impartial, because of course that would be a positive, and what they've done is a negative. They have deliberately, my complaint is, and as was clearly in the case against me, is that the people that would have been distressed by the violence and the use of violence from the guards, not myself, and in any event who would have been more independent about the incident, including the lady that we can see outside the door, who's got a clearer view, in fact, of what's going on than those who are behind the wall, because she's outside and therefore can see what's happening further down the ramp. She's not questioned. And there's no question, and of course there's people trying to use the job centre, coming in and out of the job centre, who are clearly victims effectively of the affray that's going on in the doorway, instigated by Lucy and carried out by the guards. So my complaint is that, but Judge Longman goes on to say, having made an incorrect account of what my complaint was, nor do we find that the job centre staff have deliberately lied in an attempt to incriminate Mr. Gray. Well, you can't deliberately lie. You lie or you don't lie. So it's the deliberately is a completely otiose word in this context. But in any event, whether or not they've lied is based on the evidence of the fabrications versus the CCTV of what's occurred, the contradictions and the illogicalities in the testimony in terms of being able to see through walls or when exactly the hits occurred, most of which the testimony seems to be asserting that it's happening in the doorway. How could they have seen the hit if it was round the corner, and so on and so forth. None of which is addressed or assessed. And of course, Judge Longman doesn't assess. He just says, oh, you reject that the police did not, assuming Judge Longman was supposed to be referring to the police selecting only partial witnesses, not impartial witnesses. How has Judge Longman addressed that? He just whitewashes it. He mentions my complaint about it and then ignores the glaring fact that the only witnesses that the police sought to give evidence about the incident were close colleagues of Ryan and Povey, and individuals who clearly had a vested interest, certainly in terms of Lisi, in terms of the incident on the 24th of July, let alone the 3rd of August, where she has a conflict of interest and it desperately wants me to be convicted, or indeed to be considered the culprit and not the victim of either violence on both occasions. But again, Judge Longman just simply points out my complaint and then moves on, as though his function as the judge who's supposed to determine on the law and the facts is simply a cipher for the job centre staff and David Chidgey. Having seen the witnesses from the job centre who gave evidence, and having considered their evidence carefully, Judge Longman goes on to say at paragraph 31, along with the CCTV footage and the evidence of Mr. Gray himself, we are satisfied that they have sought to give an honest and accurate account of what happened and what they saw. Well, Judge Longman doesn't even have to canvass the incident of the 24th of July for us to establish that he's completely talking utter and utterable lying filth. His position that the CCTV in some way assisted the court or helped them understand whether or not I had struck either individual is completely preposterous, given that both the complainants alleged that it happened off camera, which is why it couldn't be seen on the camera. How could the camera possibly assist in terms of establishing what had happened off the camera, or what was alleged to have occurred off the camera? And if it happened off the camera, where is there any proper analysis of what could possibly have seen from Miss Rockhatch in particular, who gives the most, who states in the most glaring terms, leaving aside Miss Smith, who reneged on her evidence. Miss Lisi didn't see any punch. Certainly Miss Brown, Jessica Brown, doesn't say that she actually sees the hit. She extrapolates, she claims, from her angle, and where is she? She's well back out of proper view of the incident. So only by proper investigation as to what can actually be seen behind the wall from the angle that Rockhatch and Lisi are standing, and Rockhatch in particular, can we establish whether Rockhatch is the only independent witness who claimed to have actually seen a blow to Smith and Ryan, could possibly have occurred if it happened off camera. And the description, as Judge Longman himself spells it out, indicates that she is talking about me this occurring at the doorway rather than, where I am, which is, I must be at least 6 foot down the ramp from the doorway, if not more, considering where, if the guards are completely off camera for moments at a time, I'm even further down the ramp than the guard, so that I'm nowhere near, by some margin, the doorway. And of course, even as I'm being pursued down the ramp, the way for Rockhatch to see is still, even if she were actually outside, standing behind Rockhatch and Ryan, behind Povey and Ryan and Birchall Vick, she would still have been blocked by the 3 individuals. So she's actually got there's another wall effectively blocking her view, both the wall from where the doorway ends to the wall created by at right angles to where the guards are pursuing me down the ramp. So and Judge Longman makes no analysis as to how she could have seen or claimed to have seen such with such clarity 2 blows to these individuals that wasn't available on the footage. And again, she can say anything she likes, because if Judge Longman is going to believe that, he would believe anything. And of course, he doesn't believe it. All he's trying to do is concoct as many ludicrous and outrageous regurgitations of the original concoctions about the punches in order to find me guilty. But of course, my case was, as I've made clear from the outset, was not simply that I didn't hit the individuals as alleged, or at all, bar the tap, which I admitted to doing, which was simply an instinctive response to the constant attacks from Ryan and Povey, which is clearly established was not the contention that I had punched anybody, and certainly which caused the alleged black eye to Ryan. And I made no such contact I did no such tapping with Povey. So the judge then goes on to issue about self-defense. This is a paragraph 32. Judge Longman says, "We find therefore that Mr. Gray did deliberately hit both Mr. Povey and Mr. Ryan in the face, and we turn to the question of whether he may have done so in self-defense. It is Mr. Gray's case that the purported ban from the job centre was ineffective and unlawful. Since the ban was unlawful, he believed that the force used by the security guards in preventing him from entering was unlawful, and that he was therefore entitled to use force himself to effect entry." This is a lie of the utmost gravity, because the judge, the claim in self-defense was not that they were not able to use force, although that was my contention. It's self-evident, I would have thought, that if you're not committing an offence, it's not self-evident, it's in the law of, I think it's the Criminal Justice and Immigration Act 2008, which sets out, section 76, which sets out the parameters of where self-defense is a reasonable excuse when you're being prosecuted for assault. And your main contention is that you are fearing violence, and you can have a successful pleading where you state that, in fact, even if it's clear from an objective observer or after the fact that you weren't actually at risk of assault at the time, you had an honest belief that you were being assaulted and you had a right to defend yourself. But my position was that the use of force by the guards was itself criminal, that they were assaulting me. They were clearly putting myself and other job users or any other members of the public that wanted to come in and out of the job centre, as was their rights, at risk of criminal violence. The position that I called the police to begin with, that again supported the use of criminal violence from the guards. But of course, the degree of force they're using, especially when at the time they're alleging that I punched them, which is pursuing me all the way down the ramp when I'm no longer even trying to get into the job centre, it was criminal violence to which I would have been allowed, had I done so, in striking them. And indeed, the greatest suffering that I endured in terms of my response to the attacks from them was that if I had attacked them with serious force, i.e., for instance, using the camera as a weapon and smashing it over Ryan or Povey's head, that would have, if I was prosecuted at all, it would have gone before a jury, and a jury would, of course, I'm fairly sure, acquitted me had I been prosecuted all the way to trial, because, of course, they could see that the violence being used by the guards was, even if they were allowed to use force, which was my contention they weren't, but even if they were permitted to use force, the force was way out of all proportion and degree to the complaint that they were trying to stop, in which the force was involved. So he's lying in his teeth about what my defence was. It wasn't simply that the force itself was unlawful, but the force, even if it was lawful, was to such a degree that I was allowed to defend myself, because clearly if they're shoving me back against ramps where they could break my ribs or cause a heart attack or cause some other substantial injury, going back to the point, of course, that they don't know whether or not I suffer from some congenital heart disorder or some other problem, which I might not even myself be aware of, which is then triggered by violence. And that's often the way of these things, that people end up being dead, even if it's just a bit of a pushing and shoving, which this went beyond. That I was entitled to use force in those circumstances. So already, again, the lying crony judge lies even about my grounds of self-defense in his eagerness and desperation to convict an innocent man of a crime that he hasn't in fact committed, and in fact that the judge knows he hasn't committed even before the trial has taken place. So, having lied about what my defence is, he then goes on, for what it's worth, to reject my defence. Further, Judge says at 33, he maintains that the only force he used was proportionate and lawful. In support of this argument, he goes on at paragraph 34, that he should not have been banned from the job centre, he cites Article 5 in his right to liberty and security. We find that this aspect of his case is misconceived. Article 5, while protecting his right to liberty, does not confer upon him the right to go where he pleases or to enter a particular place, even one which is normally open to the public. I mean, if that makes any kind of sense at all, it's egregious and wrong-headed sense, because for a start, Article 5 is liberty and security, not just liberty. So Judge dismisses the security aspect because, of course, these security guards who are supposed to be protecting all members of the public, which includes even myself, even people who are banned are still presumably entitled to some kind of security, is being is breached, not because of I'm not challenging the decision with the ban from the solicitor, because that's just a piece of paper from a civilian that I can throw out of the window. But the court's decision Judge Longman's decision to carry on prosecuting me is by its nature a breach of my Article 6 right to liberty and security. The security aspect we've dealt with in terms of the criminal violence from the guards. Indeed, the criminal violence from the guards is also an offence against the liberty and security of the other job centre users who we've already talked about. But in terms of liberty, he says the Article 5 does not give me the right to go where he pleases. Well, of course, it doesn't give me the right to enter somebody else's house. It doesn't give me the right to enter the ladies' toilet in a cafe. It doesn't give me the right to go into the Ministry of Justice premises and start rifling through their top secrets, or go into number 10 Downing Street. It's an absurd suggestion to extrapolate that my rights in going to a public building, which was my job centre of signing on with the intention of obtaining evidence of the criminal assault from Walters of a few days before, which Judge Longman doesn't mention anywhere about my motives for wanting to go into the public building, is not the same as wanting to go where I please. And it's a preposterous extrapolation to suggest that was my argument or my basis of the defence. In terms of one that is normally open to the public, well, how could that possibly be right? If there's an injunction that bans somebody from a particular area or from pestering somebody, a civil injunction by the civil courts, which has powers under the criminal law if somebody breaches the injunction, or prosecuting them and sending them to jail if necessary, that's a lawful process by which their Article 5 right of liberty and security has been weighed against greater justice about the concern for some potential or some area of the person's conduct that would lead for them to be banned by way of an injunction from an area, which is the most common form. But of course, we've got ASBOs and all kinds of endless types of acronyms that breach people's liberties, some of which is quite clearly necessary. And of course, that decision has been made by the courts, not by a solicitor's firm who said, thank you very much, taxpayer, for 10,000 quid or however much they got paid, effectively bribed for threatening me by a letter. If they want to ban me formally from the job centre, as they now have done, in fact, they do that via an injunction by bringing civil proceedings, or indeed even in the criminal courts, as happened in this case. Once I was convicted, they could then impose a restraining order that prevented me, for I think in this case, for a period of 2 years from attending the area of the job centre. Indeed, the criminal courts can even impose such a restraining order even if you're acquitted under the the Act of Prevention from Harassment Act 97, it gives the courts powers, the criminal court powers, to impose a restraining order against somebody even if they're acquitted of any offence for which they are for which the restraining order has come into relevance. So there are all these avenues open to allow me to be banned and to stop me going to places normally open to the public. But that did not apply in this case. There had been no injunction, there had been no court proceedings, there had been no restraining order imposed by way of criminal proceedings, and therefore, on what purpose could Article 5 possibly have if it did not give somebody the article, a human right to go where everybody else is able to go? Where is there the dividing line between that and stopping people going to a park because they're black or gay or all the other basic civil rights people are entitled to or normally entitled to? Simply because my name is Ben Gray, and in fact, in my particular case, because I've been the victim of a horrendous attack by Walters a few days before, that clearly does not, under law, prevent me going back into the job centre and does not entitle the job centre staff to then use any form of force that involves physical contact with me by preventing them. And of course, if I was a female, would the violence and the contact being made by these male members of the job centre staff be accepted, where they're shoving at my chest, shoving in my areas of my body that if I was a female would clearly be part of my my breasts or my other parts of my body, which would be completely and utterly unacceptable. And so just the mere fact that I'm a male, apparently in Judge Longman's eyes, somehow makes the force acceptable, or if not, he's simply allowing these staff to grab hold of and molest any female member of the anybody who was female and wanted to attend the job centre in the same way they did to me. And of course, we know in our heart of hearts that is utter and complete concoction. And in any event, how does the Judge Longman address my complaint that it was a breach of my Article 5 right, i.e. that the whole criminal proceedings were a breach of my Article 5 right? He just addresses it by just saying, I can't go to places normally open to the public. Why I'm not allowed to in my particular case, we don't know, other than the fact that we know that Judge Longman is a lying, venal crook. And that is really the reason why he's saying these words. He just wants to get me convicted. He's doing a favour for Judge Chidgey, from David Chidgey, and he's and for reasons that we will go into in further documentaries, I'm a bit of a thorn in the side of corrupt judges like Judge Longman and his colleagues, who I had dealings with already before this trial here, before Judge Longman, as we can probably deduce. Paragraph 35, Judge Longman goes on to say, in asserting that the purported ban from the job centre was unlawful, Mr. Gray further relied on what he described as a ruling by District Judge in another proceedings. Well, I won't go into that. It's a bit boring because it concerns another trial in which I was acquitted, pretty much in the same kind of altercation situation with job centre staff in that case. The long and the short of it was that you can't have two trials about virtually the same kind of incident and they have completely different outcomes. The judge in the previous trial, District Judge Williams, in 2009, acquitted me, or indeed found no case to answer before I was acquitted, i.e. before I even had to give evidence, where I was accused of an offence involving job centre staff and me having a camcorder and so forth in another job centre, but it's a red herring. But of course, the point is, if you read the whole transcript of the judgment, you will see that nowhere does Judge Longman explain how the use of force was justifiable either under Article 5 or under any other act or authority. Nowhere does he come close to clearing that matter up as he does with any other major issue in the case. Moving on to the rest of the judgment, which was nearly finished, paragraph 37, Judge Longman says, we do not, however, find it necessary to make any ruling as to the lawfulness or otherwise of the purported ban. Even if such a ban is unlawful, which is a question for a different court, that would not give Mr. Gray license to use excessive and disproportionate force in seeking to gain entry when physically prevented from doing so. We do, however, find that it is possible that Mr. Gray did genuinely believe that the ban was unlawful and that he was entitled to enter the building. Again, Judge Longman is simply muddling up whole different points of law in assessing the case. The key point, however, is that his version of my defence is a concoction. The issue was not whether or not they were not entitled to use force per se, which was the starting point of my submission, but in any event, if they were allowed to use force, the force had to be proportionate to what they're trying to enforce. And he doesn't deal with that. Judge Longman goes on to say, when Mr. Gray tried to enter the building by force, as he accepts he did, the security guard stopped him from doing so. He was not entitled to use disproportionate force in response. Well, I did not accept under oath that I tried to enter by force. I was simply trying to enter. The fact that they're using force to stop me prevented me going into the job centre, which is why I did not go in. But I did not try and use force. I simply made the movement towards the job centre, towards the entranceway of the job centre, and then force was used to expel me. There's no suggestion that I used force. He's suggesting that, in effect, he's finding that I was lashing out or punching at them just in order to effect my entrance into the job centre. A slightly moot point, considering I deny having punched anybody. But if I had punched them at that time or at any time during the altercation that involves me trying to go into the job centre, the punch would have been a reaction to being attacked and manhandled by the guards who are using force to keep me out. And that's, it's as self-obvious as the sun in the sky. But Judge Longman is so venal and such an atrocious abuse of his office of power that he's just mangling up all kinds of different versions of what my defence was, concocting my defence, concocting what had actually happened at the altercation, making no formal findings about the use of force or the degree of force used by the guards. And perhaps rather than my whittering on, we'll come on to that now, because the judge deals with this in this manner. Paragraph 39, he says, we have considered all the evidence, including that of Mr. Gray, of the behaviour of the security guards towards him. Ruth Lucy said that she did not instruct Mr. Ryan and Mr. Povey to use force, and they did not use force. It seems clear from viewing the CCTV, and indeed from what Mr. Ryan and Mr. Povey themselves said, that they did use force against Mr. Gray in order to keep him out of the building. So, with one stroke, Judge Longman points out two major criminal flaws in the prosecution case. First of all, Lucy has committed perjury because she's seen the footage, as we've all seen, of this violent attack from the guards, and then claimed under oath with a straight face, lying in her teeth under oath, that no force was used by these guards to keep me out of the job centre. That itself should amount to a prosecution under Section 1 of the Perjury Act 1911 for giving evidence that Miss Lucy knew to be false or did not believe to be true, which is the criteria for someone committing perjury, and that should have been that in terms of prosecuting me. Judge Longman refers to it, because he's such a liar himself, as in passing. He doesn't even establish. He even establishes that Miss Lucy has got it wrong by saying that it seems clear from viewing the CCTV, and indeed from what Ryan and Povey themselves said, that they did use force against Mr. Gray in order to keep him out. So they have Judge Longman agrees that force has been used, and that Miss Lucy has clearly not told the truth when she said that force had not been used. And then just simply moves on calmly, as though Miss Lucy's bold-faced, because Miss Lucy is the instigator of it all. She could have immediately asked for the doors to be shut as soon as there was some pushing and shoving from either party. She did not do that. She allowed the fight to go on and on and on, with other members of the public put in danger and harm's way as they're coming in and out of the job centre. Women outside terrified of coming in because of the violence that Miss Lucy herself is pursuing. And having instigated all that violence, she goes casually into a Crown Court and under oath, in front of a Crown Court judge, says what is completely the opposite of the truth, that no force was used. And clearly she's also, in that lie, asserting that she has not condoning or encouraging the violence and the force that was used by the guy. And of course, the word force is one of those weasel words, isn't it? That's always trotted out by those in authority, where somebody in power kills or maims or injures somebody, sometimes justifiably, of course, and perhaps often justifiably. But it's violence at the end of the day, and in a situation where it's force that's used, where you're shoving people against railings and so forth, then of course it's criminal violence as well. But I shall stop my own complaints and carry on with what Judge Longman says at paragraph 39. He says, Mrs. Rockatch said that the security guards were trying to stop Mr. Gray from coming in. They were not aggressive. Well, again, we heard the tape, unfortunately, or we didn't hear the tape, unfortunately, but Judge Longman refers to the tape that was heard in the trial and in the proceedings, and of course this is recorded for posterity, so perhaps in the fullness of time we can get the transcripts of it, but you can clearly be, not only it was Povey and Ryan mentioning the fact that they had been hit and assaulted, which of course they would do if they're going to trump up a charge of that nature for later proceedings, but you can hear Povey in particular shouting at the top of his lungs, "Fuck off!" You can see him where he's in the photograph here, and in the photograph I showed you in the stills of the footage itself, where he's bellowing, "Fuck off!" And of course, the violence they're using, throwing me against railings, in the eyes of Miss Rockatch, is not aggressive. Clearly, if Miss Rockatch believes that throwing an innocent male against railings for trying to enter a job centre and no other further complaint of any form of conduct against him, yes, we've got the throwing of chairs, but we've seen about all that. But somebody who's not actually got any injunction or prohibition against doing something, that the force used involves throwing someone again. I mean, even if I was some heinous offender trying to get into the job centre, and of course heinous offenders use job centres all the time, people who are on parole for murder and God knows what, they're able to come in and out of the job centre without any problem at all. But in any event, they are being aggressive. Again, bold-faced perjury. The Judge Longman he's torturing me, is he not, ladies and gentlemen, by rubbing my face in these concoctions in order to justify convicting me, rather than suggesting that Povey, that certainly Rockatch and Lisi should be investigated for perjury, even on the testimony they give about the force that was used by the guards on its own is evidence of their lying. And of course, it reflects on other testimony they're given, Rockatch in particular, because she's the only one that claims to have seen me hit either party, let alone both of them, through a brick wall. I mean, not hit them through a brick wall, but be able to see it through a brick wall. Jessica Round said that there was no aggression from Mr. Povey and Mr. Ryan. Well, the same applies obviously to Jessica Brown as to Lisi as to Rockatch. Paragraph 41. The CCTV shows that both security guards did use force against Mr. Gray in preventing him from entering the building. So they did use force. So he's convicted me. If you remember earlier in his conviction, in his finding that the punches or the blows to Ryan and Povey's eyes from myself, that allegation was established mainly, indeed solely, because the footage doesn't show anything of the sort, solely on the evidence of the three females that he then basically finds to have been lying in their teeth about the degree of force used, about force, whether force was used, aggressive or not, because force would be aggressive by its nature. He dismisses that. He clearly knocks their evidence into the middle of nothing, because he's established that there was force used, and that these individuals who were watching the footage as it's unfolding, saying that there was no force used, was completely wrong. And if they were wrong about that, then why has he found their evidence to be credible when it comes to the punches, which again relied entirely on their evidence? So again, it speaks for itself. Paragraph 42. Mr. Gray gave evidence that security guards were pushing him against the railings by the ramp which leads to the entrance. Mr. Ryan accepted that it was possible that Mr. Gray was pushed back into the railings. He accepted it was possible. You can see him doing it twice, ladies and gentlemen. First on this occasion, and then on this occasion. Twice. And yet, so what on earth difference does it make what evidence Ryan gave, except that if he only thinks it's possible, when you can see me doing it on 2 occasions, again, what does this say about Judge Longman and Mr. David Chidgey? Paragraph 42. Judge Longman says, Mr. Gray gave evidence that the security guards were pushing him against the railings by the ramp, which leads to the entrance. Brackets, Mr. Ryan accepted that it was possible that Mr. Gray was pushed back into the railings, and the CCTV does not suggest otherwise, close brackets. Well, again, do I really need, I'm sure I hopefully don't by this stage, but what does Judge Longman, what is he talking about? For a start, what relevance is Mr. Ryan's evidence really to do with anything other than, given that you have the CCTV footage proving what has occurred? I mean, the only thing that is relevant is what a liar Mr. Ryan is. If he's seen me on 2 occasions, here is the first occasion, and then here's the second occasion of me being physically shoved against railings for trying to come into the job centre. Let's not forget, because they've been punched or alleged to have been punched by me, because that occurs off camera, as we've long since established, or the claim that it has occurred is off camera. So they're simply, in order to prevent me coming into the job centre, using such violence that are clearly putting my own life at risk. And Mr. Ryan doesn't even, he says it's possible. How could it possibly be his answer that it's possible when the footage shows it is actually happening? And why is the CCTV, in Judge's view, suggesting something? It's hard evidence of what has actually occurred. He can see me with his own judge's eyes being shoved against railings. So why does he have to use the weasel word suggest rather than simply find that that was the force that was used, force that was so violent as to clearly be life-threatening and clearly be threatening the well-being of other people as well? People can die of shock, mere shock, in terms of a violent or horrible incident that triggers some kind of reaction, including heart attack and death. And of course, I'm not the only one who's been subjected to the shocking violence courtesy of the security guards. Judge Longman then goes on to say, Mr. Gray said that Mr. Ryan put his hand in his face and was shoving him. Mr. Povey, he said, seemed to have lost the plot and was like a rabid dog and had to be held back. He said that one of the two jabbed him in the ribs. In response to that assessment of my defence, which is largely correct, Judge Longman says this: having seen all the witnesses giving evidence and having considered the CCTV footage, we are satisfied that the blows which we have found to be delivered by Mr. Gray against Mr. Ryan and Mr. Povey amounted to excessive and disproportionate force over and above anything that could amount to lawful self-defence, taking into account the circumstances as Mr. Gray believed them to be. We find that the blows in each case, and we have considered each charge separately, amounted to force which was excessive and therefore unlawful. So, ladies and gentlemen, that brings us nearly to the end of the documentary and obviously to the end of Judge Longman's judgment. There's 2 paragraphs there that I've just read out, and of course the second paragraph is supposed to deal with the first paragraph. The first paragraph deals at paragraph 42 with the level of violence I've complained about from Povey and Ryan, and pointed out that the Povey can be seen on the footage, and here it is in slow motion, needing to be physically restrained by Ryan to give an indication of how violent he was. The tape, which we haven't heard but was played and could clearly be heard, Povey shouting "fuck off" at the top of his voice. But the violence generally of me being pushed against railings, and here we see, of course, already mentioned the way Judge Longman talks about me being pushed against railings and how the footage does not suggest otherwise, that very delicate and completely unclear position that he takes when disagreeing, when Ryan gestures towards the fact that he has shoved me against railings, when of course the footage proves that that's exactly what he has done on at least 2 occasions. But yet then when he goes on to the second paragraph dealing with the paragraph 42, at paragraph 43, he then gives no indication about why he's found that the violence that I was allegedly using was disproportionate to the violence that has been described by me from the security guards. And that's not only just clearly biased and prejudiced, but what he's doing is colluding in the criminal violence that's being carried out against me in order for him to justify convicting me for the alleged blows that themselves cannot even be proven. And of course, when the blows have been allegedly carried out, I'm being pursued down a ramp, having been pushed against railings and been subject to other kinds of violence of that description. So again, I've relived the whole ordeal of the 3rd of August, and the taxpayers forked out thousands and thousands and thousands of pounds for my defence to be in the alternative. Although I didn't hit them, but even if it was proven I'd hit them, I was entitled to do so in terms of self-defense. All of that just goes by the board because the judge refuses to engage on why he is saying that the violence he's not even clear as to why. He's not specifically said violence was used against Mr. Gray, although he's implied that he does accept that because he's dismissed Ruth Lacey and Rock Hatches and Brown's perjured evidence that the guards were not aggressive and were not using force. He sort of he dismisses that. He accepts that even Ryan himself, to some extent, accepts that he pushed me against railings, but then refuses to say, well, why that's perfectly reasonable or not perfectly reasonable conduct, or why it would not be understandable if I thought within the context of that sort of violence from that many people, all of whom are large males, it would not be justified in terms of striking them to get them away from me or in immediate fear of immediate violence. Bearing in mind that Section 76 of the Criminal Justice Act 2008, and I'm going to mention it even though Judge Longman doesn't, even though that's the main purpose of his job when assessing such issues as the ones that are raised in this case, that the Section 76 says that it could be mistaken belief and that you can even strike somebody as a preemptive strike before you're attacked by them, because you genuinely believe that you are about to be attacked by them. Well, I'm clearly being attacked by them, not about to be attacked. I am being attacked by them, and I'm clearly therefore entitled to use criminal force, use reasonable force that would otherwise be criminal if I was not under attack. And of course, I know, apart from anything else, all I'm done is left with is feeling absolutely outraged and resentful that not only about the attacks, but the way Judge Longman has covered them up. It's not indicated to me what I've done wrong, because he doesn't indicate to me why the violence that I use or allegedly use against the two guards was disproportionate to the violence that's being used against me. So he's not even. The primary function is even assuming that my guilt was justified, or his finding of guilt, Judge Longman's finding of guilt, was justified. In terms of learning a lesson and punishing me, bearing in mind the suspended sentence I received and the banning from the job centre and having my face published in the press, to saying that I've been banned from every job centre in England and Wales, he's not teaching. I'm not learnt from that position whereby. At least I know that the violence I used was disproportionate, because there's no mention of the proportionality to what. It has to be proportional to something that Judge Longman refuses to engage with or even state in his judgment. Of course, all that is fairly obvious, and there's no point in me, I hope, banging on about that matter. I then appealed the conviction to the, just for completeness, I judicially reviewed at considerable public further expense the conviction to the High Court in London under judicial review criteria, and Mr. Justice Silber accused me of, on paper, he refused a hearing and made the decision on paper that mere disagreement with the judge is not a foundation for an appeal or a judicial review. Well, I didn't merely disagree, as we hope the last 3 hours of the documentary have disclosed. I referred to all the evidence of perjury and lies from the judge and perjury from the witnesses, the judge, and of course the violence and the cover-up of violence. All of that was adumbrated, and you can go, of course, again to bristolspotlight.tech and download or look at Chidgey File 1 and all the documents related to that judicial review, as well as all the other documents we've seen to some extent in the documentary, can be looked at, and you can see that I provided some 30-something pages of submissions about the grounds of appeal, and based on human rights and Section 76 of the Criminal Justice and Immigration Act and all the other points of law and the evidence. And all I get in return is this judge, Mr. Justice Silber, who not only accused me of being totally without merit in terms of the application to have the conviction by Judge Longman quashed, but then imposed what's called a general restraint order, which prevents me litigating again in terms of any other appeals. I now have convictions now, which I'm in summary court proceedings, which I'm unable even to appeal to the High Court to have judicial oversight, because I've been subject to this general restraint order now for a decade, for almost as long as this since this incident occurred. Whereby the High Court judges like Mr. Justice Silber are giving the nod to crooks like Judge Longman, who then in turn give the nod to crooks like David Chidgey, and all the way down, obviously, to the local Avon and Somerset police. So again, there would be no point. It would be a complete fool's errand to go through the judicial review if you couldn't obviously check out the decisions on that. I just put the final decision of Mr. Justice Silber on the screen just for completeness sake. So that, ladies and gentlemen, is my documentary one, in terms of this, the expose, in terms of the corrupt criminality of Judge Longman. Has Judge Longman complied with his oath to the Queen to do right by all manner of people without fear or favour, without affection or ill will? Of course he hasn't. He's lied. He lied when he gave that oath to the Queen, because he's done no right to anybody in this case, including, I suggest, even people like Miss Lisi and the security staff and the police. He may, they may feel that they've achieved something by perjuring themselves in the Crown Court and have got away with the violence from the 24th and the 3rd. And may feel very proud that they have people like Judge Longman and David Chidgey in their pockets. But as we can see from the further attacks, here is an example of where complainants Ryan and Povey were involved in a far more recent incident of violence, where they've restrained an individual for vaping, which isn't even the same as smoking, even though the Bristol Post story refers to it as smoking, and that gives you some indication of how biased and corrupt the Bristol Post is. But it gives you also an indication of how the security staff clearly feel that they can get away with continued violence against people that use the job centre and then use the taxpayer and use the summary justice system to use their cronies in the Crown Court to allow them effectively free rein to attack who they want, when they want, and how they want, with the police, of course, backing them up to the hilt. I don't say for a moment that this man in particular was innocent or guilty. All I can say is that there should never have been a trial, because Povey and Ryan should be nowhere near a position of office where they can use violence, given the context of the case against me in 2009-10. They are clearly perjurers, and therefore the evidence they gave, bearing in mind that the individual in this case, the one where this man was vaping, relied not on CCTV, because again the CCTV did not show that the blow alleged. So here we have a completely a facsimile of the case against me, where a man is accused of hitting one of these guards whilst being forcibly restrained by the guards. And then the CCTV footage, as the Bristol Post story says, was inconclusive, i.e. it did not show show this man hitting either of the guards, and therefore again the footage, the playing of the footage becomes redundant, because it's meaningless in terms of evidence that the man has carried out any form of assault, exactly as with me. But of course, it then leaves the case entirely dependent on the credibility of Povey and Ryan. And Povey and Ryan, I don't know how credible their evidence was per se in the trial on that case, but we know they are utter perjurers from the evidence we've seen in this documentary. And they would not. It is almost safe to assume that whatever incident occurred over this man vaping, if it didn't involve Povey and Ryan, and if Povey and Ryan had been held to account for the violence and corruption and lies in the 2009 incident, both July and August incidents, then of course things might have been differently from this gentleman. And of course this gentleman is simply one of an individual who happened to have made the Bristol Post, when of course there have been, I'm sure between now and then, the last decade or so, many other such incidents involving Povey and Ryan, and of course security staff from other job centres as well. But ladies and gentlemen, so let me just go through a very brief tally of Judge Longman's offences and David Chidgey's offences, and then that'll be the end of the documentary. Just taking the 24th of July, where we can see here there's all manner of offences in terms of the assault that was witnessed by Elizabeth Evans. We see the assault that we can see on the camera that's carried out by Ryan, and we can see the assault by Walters. We can see that Ryan then lies in terms of his later testimony to the police that I've been throwing chairs about. We can see that the missing CCTV footage that PC Ma, who was investigating me for a fray and my counter allegations against Walters, deliberately did not seize the footage. The footage was then allowed to be destroyed or disappeared, or was never retained anyway, so that I could then prove that I'd been been attacked by Walters, that Walters' version of events, albeit completely different from Ryan's version of events, were both concocted. And then the criminality of these officers, Hawkins, etc., who arrested me with brutal force, putting handcuffs too tight on the injuries I'd already received when I smashed my hand against the corner of a wall to steady myself after Ryan had me bent double. Walters had me bent double over the seats a few minutes before, and the concoctions from the officers that I was had committed a breach of the peace when there'd been the only evidence that existed, even by the version of Inspector Chambers, showed me to be a victim or potential victim of violence. And then, of course, all of this led to the violence that was then carried out on the 3rd of August, which is then whitewashed by Judge Longman in its entirety. The criminal violence being carried out, throwing me against seats. And in both these incidents, we can see innocent civilians being terrorised by the violence that's then that's already being instigated by security staff. The rights of these individuals also should count for something, and it is surely in their name, if not my name, that Judge Longman is carrying out his judicial duties when considering this evidence. The perjury, the lies from Judge Longman himself, the lies from Lisi and Smith on every single count, beggars belief. The missing cameras, the missing photographs that DaCosta claimed to have taken of the black eyes to both Ryan and Povey, the injury that Judge Longman inventing evidence given by Mr. Dick and Miss Lisi, who both claimed to have seen injuries before, just after the incident at the doorway and before Ryan and Povey had gone to see Nurse Moran. Judge Longman simply casually concocts that up and says, oh, well, maybe they saw the injuries after they'd gone to see the Nurse Moran and then gone to give evidence to DaCosta. So he effectively calling those two individuals liars when they told the court under oath that they'd seen the injuries before, immediately after the incident involving myself and before they'd gone to see Nurse Moran. And on and on and on Longman goes. He casually dismisses the point that Lisi and Rockhatch and Jessica Brown had given evidence that there had been no aggression from these security staff at any stage, and that they did not use force to keep me from the job centre. Perjury on an almost surreal scale. I mean, something that you would have difficulty inventing, even if it was for a purely fictional fantasy novel, rather than that's occurring in a British courtroom circa 2010, and giving a lie to all of those politicians and all of those journalists who tout this country as being a country that follows the rule of law. It does nothing of the sort. You try, ladies and gentlemen, if you wish, contacting either an MP. My MP is Kerry McCarthy, and I've been making her well aware of these complaints for nearly a decade. She has simply stonewalled me to the hilt on every single complaint I've made. And of course, the journalists who I've contacted, and I've rung the Guardian, the Bristol Post, of course, the Independent, the Times. All of them are literally, if you actually get through to a journalist, a front desk journalist, and start talking about having evidence of police torture and brutality and collusion and perjury and perverting justice from Crown Court judges or any senior judge, you're lucky if you don't actually get abuse from the journalists down the phone whilst you're talking to them. And of course, in further documentaries, I can play some of that abuse for future reference. But I hope you understand, ladies and gentlemen, that my concern isn't just about the resentment that I feel, the trauma and degrading humility of having to relive being detained and forced to urinate myself in front of a female police officer and after being attacked by people like Mr. Walters and Mr. Ryan. All of that obviously is a cause of great resentment and anguish to myself, and of course fear. But the fear is surely the whole of the public justice system is surely in a state of absolute anarchy and terror if people like Judge Longman are allowed to sit unaccountable in a position of office as they do.